Happy New
And
Year,
yeah,
my
your
lord.
lordship.
Happy New Year. Happy New Year. My lord, may I have a lordship's one indulgence to your lordship, my lord? One very urgent pill matter, my lord. I have filed, my lord. It is filed, my lord. It will appear, my lord. But my lord, urgency.
It will appear on Thursday.
My lord, my lord. But there is a urgency, my lord, because my lord.
What is the urgency?
My lord, my lord. One Sujoy Krishna Bhadra, an accused person of recruitment scam, my lord, is unnecessary and deliberately keeping one bed, my lord, blocked, my lord, admitted in the SSKM hospital, my lord. And my lord, this is stalling the investigation of the ETA enforcement director, my lord. If your lordship kindly.
You serve notice on the respondents.
My lord, I have already served, my lord.
No, on the advocates who are appearing.
Okay.
You serve. Thursday it will be taken as.
Okay, my lord. As your lordship.
Yes.
My lord, if your lordship kindly keep it on top of the list.
Yes, definitely.
Deep level.
I, Piyush Bandyopadhyay, petitioner in person of WPA 26486 of 2023, is praying food and medical treatment from Honorable Justice High Court, Calcutta, Code number 1, Division Bench. I filed series of petition and I am without actually retirement benefit last 6 years, 6 months. And the matter is most urgent, and the matter is actually under motion C, a new motion C, item number 481, before Honorable Justice Obijit Gangopadhyay, due to excessive pressure, your lordship, the matter not listed till today hearing. And I am actually.
The problem is on the administrative side, unless the concerned court releases the matter, I cannot reassign the matter.
Neither the matter release, your lordship, not the matter listed. I am praying food and medical treatment. I will follow the list, your lordship. I am praying food and medical treatment.
Under compelling circumstances, we are permitted to mention. I mentioned a matter on October 14 rules even before my lord Justice Standard. My lord was last day. My lord was pleased to take the matter, but personal difficulty. My lord was pleased to release the matter. The matter is extremely urgent.
No, release the matter. I have up to 22nd. Whatever matters were released, orders signed. I have already assigned it.
My lord, the file is before my lord's secretariat.
Today
we have already stated. I have a talk with my lord's secretariat, but unless it is assigned.
No. Assignments are never kept pending so far as I am concerned. You just give this letter to the secretary today to OSD. It will be done today. If it has not been done on 22nd, it will be done today.
Appellate side, daily list, serial number 1.
Yes.
For the petition, my lord. My lord, in respect of item number 1, I am seeking for an accommodation for 1 week because my lord, there was a direction upon me to submit a supplementary bit on behalf of the remaining of the students, my lord. My lord, I tried my best to get in touch with them, my lord. Most of them were out of station. My lord, I just need 2-3 days time, my lord. It is ready. Unless it is being signed, I will not be able to file.
My lord, I will request your lordship. My lord, I appear for 2 persons who were brought under arrest before your lordship. My lord, the examination in Karnataka State Nursing Council is going on. That's why, my lord, they could not enter appearance before your lordship today. My lord, they have sent me tickets. They will enter Calcutta within 10th.
Okay.
My lord, I will request your lordship to kindly fix the matter any day after 10th, subject to your lordship.
So we will fix it in the other regular, because this combination.
As your lordship pleases.
Continuing matter.
May I get the copy of the affidavit filed by them?
No, let them first sign it. At the request of the learned advocate appearing for the petitioner, time granted for filing affidavit by the students stands extended. List the matter on 16th. January.
I'm grateful.
In the same caption.
And my lord, the interim bill may kindly extend it till.
All right. The interim bill are already granted and extended from time to time, stands extended till the next hearing date.
My lord, there is one more thing that is, my lord, there was one, if you lordship kindly produce the last 2 orders, there was a direction upon them as well to serve a copy of the affidavit. My lord, compliance has not been made from both sides. So that is being the reason, my lord.
We have already supplied. They have not served us the copy of the writ application.
Yes,
we have already supplied the copy of our affidavit. If your lordship directs, then we will further serve, my lord.
You give the copy of the writ
I will, lordship. That is being the reason.
He will not record anything.
Yes,
lordship. All gentlemen agree.
I'll leave it to you.
Yes, next.
Extremely grateful.
Serial number 2.
We are for the respondent in this matter.
Why
I appear
appellant
for the-
nobody is appearing?
I appear for the state, non-answering respondent in this matter.
No, most probably the appeal is infructuous now, my lord. It is regarding investigation, my lord, seizure. They have challenged the same. What is the basis for seizure? Reasonable belief. So, my lord, they have challenged the same. The honorable single judge has granted, dismissed the matter, my lord.
And personal appearance was on 10th of July.
10th of July. Nothing
So
is
the summons doesn't survive when
survived.
none appears for the appellant. We have heard Mr. K.K. Meity for the CGST authorities and Mr. T.M. Siddiqui for the state. On going through the order impugned in this appeal, we find nothing would survive in this appeal since in the writ petition, the appellant had impugned a summons dated 17 July 2023, by which the appellant was directed to personally appear on 10th July 2023. Thus, by effects of time, the summons has worked itself out. And apart from that, the writ petition has been dismissed, giving liberty to the appellant to make appropriate application in accordance with law for release of the seized material. And if such application is made, the same was directed to be considered by the respondent authorities in accordance with law. Thus, we find no grounds to interfere with the order impugned. Appeal dismissed. Next.
Serial number 3.
May it please your lordships. My lord, I am appearing for the appellant in the matter. The first day of the year, and I don't have a very good case before your lordships. My lord, I was not there in the writ proceeding, and my lord, the appeal was filed without my lord, my consultation, so I would have advised not to file this appeal because there is really nothing, my lord, which I find is wrong in the impugned order. Because may I only encapsulate this? The reason, my lord, why the order was passed, the impugned order, is the writ petition was filed my lord, on 6th of March 2022. My lord, it's a proceeding under 148. Absolutely wrong in law. Could not have been proceeded with. But it is on the jurisdictional issue that the writ petition was filed. It is not prior permission under 151 was to be taken from the principal chief commissioner, and it was taken from the principal commissioner. That was the point. And also, my lord, the reply was given. 148A-D was, my lord, issued after the expiry of 1 month. So the time frame was not followed. These are two basic points in the writ petition. It was filed on 6th of March. I'm sorry, my lord, it was filed on 9th of March. And the petitioner did not know, and also it was not, my lord, the lawyers were not instructed, that a final order under 147 was issued by the department on 6th of March, 3 days before the writ petition was filed. The explanation which has been given in the present, that this was brought to the notice of the writ court by the lawyers appearing, where, my lord, the honorable single judge recorded that the order was passed on 6th of March 2023. It is not impugned in the writ petition, and the writ petition was filed on 9th of March 2023. Hence, I'm not entertaining the writ petition. Nothing wrong in the order. Perhaps the only point which the learned lawyers who were appearing in the court, as far as I'm instructed, they had prayed for leave of the court to file a supplementary and bring this order on record. But there's a practical difficulty, my lord. Had this been after the writ petition was filed, that the order is passed, that supplementary could have been granted. But I do not find anything wrong in this order.
But you can still file an appeal before the commissioner. And in
Lord,
that,
but may I only pray for this? Because I had, my lord, this was what I had suggested.
we'll leave all points open,
Lord,
including the correctness of the proceedings under 148.
Lord, this needs to be tested in the writ jurisdiction, whether, my lord, the jurisdictional facts are made out, whether the authority has jurisdiction. I'm only praying for this, my lord, today. If the appeal is disposed of, my lord, with a liberty, I know, my lord, no liberty is required for a fresh writ petition to be filed. But, my lord, if we go with a fresh writ petition, perhaps the honorable court will then not entertain because the 147 has been passed. I'm only praying for this, my lord, if it is disposed of with this recording, my lord, that the parties are at liberty to proceed, my lord, and file a fresh petition if necessary, my lord, in accordance with law.
But 140, once the reassessment order is passed, facts have to be gone into.
Lord,
so in addition to the factual issues, you also raise the issue relating to the validity of the reopening.
Validity of the reopening.
Before the appellate authority.
The only difficulty is not before the appellate authority, they'll have to make a pre-deposit on a palpably bad order in law. That's the only difficulty. Today, if there's a jurisdictional issue involved, I'm only praying for this, if it is disposed of, because there's also a delay of 26 days. And the explanation which has been given me, I only indicate that part. In the appeal, it's paragraph 5. May I only request your lordships to take up one page, page 9, the first paragraph. Page 9 of the stay petition, my lord, the first paragraph.
Yes.
Your appellants submit that the writ was prepared by the advocate on 1st March, was affirmed on 2nd March. After late hours, it could not be submitted to the department. Thereafter, law clerk's strike was on from 3rd March and public holidays in between, due to which the clerk submitted the copy of the writ on 9th March. In the meanwhile, reassessment order was passed on 6th March. This is the factual, my lord, instruction which we have. This is what had happened. I'm only praying, my lord, since there's a jurisdictional aspect involved, my lord, if
What
the
do you say,
petitioner...
Mr. Raj?
Lord, so far as his only concern is, my lord, he will have to make a deposit. My lord, that deposit your lordship knows, my learned friend knows, my lord, there are provisions in the act. I will not advise him, my lord, he is well advised. My lord, under which he can seek stay. My lord, these stays are granted. My lord, in graver situations, my lord, your lordship has refused, my lord, to exercise your lordship's jurisdiction. My lord,
The only thing what he says is, this reassessment order was passed on 6th March, but much prior to that, the writ petition was prepared and signed, affirmed, but could not be presented because of the law clerk strike.
Lord, whatever,
Force
Lord,
majeure
writ petition, Lord, ultimately came to be filed, my Lord, after the assessment order being passed. My Lord, your Lordship, my Lord, in a similar case, where writ petition was filed, my Lord, during pendency of the writ petition, assessment order was passed, your Lordship has refused, my Lord, to exercise, my Lord, this jurisdiction. Therefore, my Lord, your Lordship is well aware, my Lord, of those lines of cases, my Lord, when a writ, my Lord, your Lordship is exercising writ jurisdiction, my Lord, being a high court. My lord, this honorable court itself has, my lord, an appellate jurisdiction under 260A. In such cases, my lord, your lordship will be, my lord, more cautious, my lord, in giving credence, my lord, to writ petitions filed. My lord, if the same
We can
court has
file an
two
appeal, sir.
jurisdictions,
That will
yes,
be better. And we will,
yes.
as pointed out, we will say that the appellant will be at liberty to seek for stay of the reassessment proceedings, and the commissioner appeals.
Stay of the demand.
Stay of the demand, and the commissioner appeals can consider that prayer before taking up the appeal petition.
That's section 220, subsection 6, my lord, for the 156 to be stayed.
No, if it is high-pitched assessment, stay is invariably granted.
My lord.
Even the High Court will put you on terms, the commissioner will grant stay, because CBDT circular says,
Yes.
unduly high-pitched assessments have to be stayed. Otherwise,
I leave it to your lordship, my lord.
this intra-court appeal by the writ petitioner is directed against the order dated 31/3/2023 in WPA 5908 of 2023. In the said writ petition, the appellant had impugned an order passed under section 148, impugned the notice dated 27th May 2022, issued under section 148 capital A within bracket small b of the Income Tax Act 1961 within bracket the Act, and the order dated 27th August 2022, passed under section 148 capital A within bracket small d of the Act, and the consequential notice issued under section 148 dated 30th June 2021. The learned single bench dismissed the writ petition on the ground that prior to filing of the writ petition, which was done on 9th March 2023, the reassessment order was passed under section 147 of the Act on 6th March 2023. Therefore, the learned single bench observed that the reassessment order being an appealable order, the appellant should avail such alternate remedy. Aggrieved by such order, the present appeal has been preferred. After we have elaborately heard Mr. Praneep Bak, learned advocate appearing for the appellant, and Mr. Romnaran Roy, learned standing counsel appearing for the respondent department, we find that no good grounds have been made out by the appellant for interfering with the impugned order. At the same time, we may observe that if the appellant is if the respondent department is proposing to effect recovery proceedings, it will be well open to the appellant to file a application for stay before the appellate authority and pray for not enforcing the demand till the appeal is heard and disposed of. We make it clear that in the appeal which has to be preferred before the appellate authority, the appellant will be entitled to raise all questions of law and fact, including the validity of the reopening of the assessment by resorting to the power under section 148 capital A of the Act. With the above observation, the appeal stands disposed of.
I'm very deeply obliged.
Very deep.
Next.
Serial number 4.
Yes.
In this application, we're challenging the order dated 14th April 2023, passed under section 148 AD. My lord, we have challenged it on the two grounds. My lord, they have issued the show cause notice on 17th March 2023. In response to the show cause notice, we have filed a reply on 4th of April 2023. And they have issued the notice on 5th of April. We have filed a response on 7th of April 2023. And they have passed the order on 12th of April 2023. Well, my point is that they have not considered my reply on 4th of April 2023.
Let us see the 148 AD order.
AD order, my lord, kindly come to page 192 of the application. Total non-speaking order, my lord.
But at page 194, they say the assessee submissions dated 6th April and 7th April has been carefully gone through.
Yes, my lord. I am saying, my lord, 4th of April, my reply dated 4th of April has not been considered at all, my lord. In the 4th of April 2023, we have filed a reply along with all the documents. Therefore, the allegation is that their unexplained income has been made. Well, we have produced all the documents. By producing all the documents shows that this income has been
Where is
recorded.
that 4th April?
4th April, my lord.
You show the acknowledgement, acknowledgement.
My lord, kindly come to page 35 of the petition. The last acknowledgement number, last 6 digit, 4040423.
35.
Page 35. Annexure C. My reply at page 37.
No, on what date was it uploaded?
Yes, my last 6 digit. My kindly see page 35. Acknowledgement number last 6 digits. This is the date 040423. Is the 4th April 2023. We have uploaded.
Where is it?
Acknowledgement number is the top of the right side of the page 35, my lord. The acknowledgement number last, kindly see the last 6 digits.
4423.
Yes, madam. This is the uploading date, my lord.
And
kindly see my reply.
No, did you seek for a personal hearing? In the reply, you see?
My lord, in the reply, my lord, subsequently we have asked for the, my lord, then kindly come to page reply dated 7th.
Ledger copy of 15 CA, audited copy of accounts, statement for bank transactions.
And for form 15 CA. My lord, if the foreign remit is made, we have disclosed everything. My lord, we have categorically stated that this financial year.
Mr. Dutt, in page 194, para 5, should he not discuss about what he has mentioned in his reply?
Yes.
Appellant submissions dated so and so has been carefully gone through, along with the ledger accounts kept on record. In this case, information was received so and so. Perusal of the investigation. But what he has to do is investigation report is a material. He has produced some document to controvert that this transaction was not an unaccounted. So we'll send it back to the
Can lead to so only one thing I have to say. Perhaps the impugned order will show that this was not the point raised before the first court.
Well, it is same thing happening in all the matters. Writ petition shows in the writ petition, there is averment is made, my lord. Well, kindly see the page 190.
No, what I may make 10 abovements in the repetition.
I should
Yes,
not
what-
say
I
anything in
place
the
only
court,
one.
my lord. Well,
I am place only one. So that it's not the fault of the learned judge, Miller, that he has not dealt with the others. Because I
So
did
if
not
you-
place them.
If you have not argued that point, then
we have specifically mentioned the writ petition, my lord.
because you are not appearing,
No, I know, my lord, that is what I'm saying. My junior appeared. That is what I'm saying. my lord.
Mr. Dutt had appeared, so he will know what was the.
That was not the
This is
argument
main
made
point,
before
my
the
lord.
court.
Well, kindly see the writ petition. It is there, my
What
lord.
is the fault of the court? Miller, they have not argued the point. They may
See.
have taken number of points in the writ petition.
The contention which was advanced was approval was not taken. That was
Yes.
Well, it was there, my lord, in the writ petition, my lord. Also.
Maybe
then
the
we will
point
give you
taken.
liberty to file a review.
My lord, review, my lord, kindly, I have filed one application before the my lord has directed in one of the matter. And I have filed the application, my lord. So only when direction will be affidavit to be given, my lord. It is long back. Nothing, they have not filed any affidavit till date. And my lord has
Because he is right.
well,
when
this is a
saying-
crisis should not be suffered, my lord. This kind of order, my lord.
But then you can give up this point regarding
Yes, my lord. I am
approval.
151. I will not take, my lord.
151 point you can give up.
I will
and
not
you
take,
can-
my lord.
We will
But-
give you liberty.
my lord,
to
kindly record that this is this point I will not take up in the before the quasi judicial authority also. This is not the actual point, my lord. Actually,
see
my
how to test see, we are testing the correctness of an order passed by a single bench. We
appreciate it.
cannot be setting aside the order on a ground which was not urged before the learned single bench. And he had no opportunity of controverting that
Absolutely.
ground.
Well,
Not raised before the first court. If you had raised before the first court, negatived or not considered in the proper manner, so we will give you liberty to file a review, saying that 151 point, the appellant is not pressing. But with regard to non-consideration of the representation, violation of principles of natural justice, the appellant is granted liberty to file a review.
I appreciate, my lord. Kindly, the litigation, my lord, we should not expect that
What to
litigation, more litigation. My lord, this is
What
small,
to do, sir?
only,
What
my
to-
lord. My
You
lord,
miss the bus.
my lord, only.
We are giving you liberty. Definitely, the learned single bench will consider.
Well,
that.
other way- well, kindly appreciate, my lord. This matter, my lord, kindly say palpable illegal, my lord. They have not considered my reply. If my lord friend said that this is there, considered,
No,
then I
if
am
we have
out
to
of
allow
court, my
your
lord.
appeal, we will have to set aside this order. This order, there is nothing on going through the order. There is nothing wrong with this order. How do we interfere? This intra-court appeal by the writ petitioner is directed against order dated 17th July 2023 in WPA 14638 of 2023. In the said writ petition, the appellant had challenged the order dated 12th April 2023, passed under section 148 capital A within bracket small d of the Income Tax Act 1961 within bracket the Act for the assessment year 2019-20. As could be seen from the impugned order passed by the learned single bench, the point which was canvassed before the learned single bench was that the order dated 12th April 2023 has been passed without approval from the specified authority as prescribed under section 151 within bracket 2i's of the Act. The learned single bench has considered the said point and rejected the challenge to the order dated 12th April 2023 on the ground which was urged before the learned single bench. Today before us, the learned advocate appearing for the appellant would submit that the appellant is not pressing the point concerning whether the approval was obtained from the specified authority or not. But more importantly, the appellant seeks to canvass the ground that the reply to the show cause notice reply dated 4th April 2023, given to the show cause notice dated 17/3/2023 has not been considered. Apart from that, it is submitted that in the order dated 12th April 2023, in paragraph 5, the authority has merely recorded that the submissions of the assessee has been carefully gone through and the ledger accounts which were furnished by the assessee were kept on record. without discussing about the documents which were placed by the assessee, nor considering the reply given by the assessee, more particularly the reply dated 4th April 2023. If this contention raised by the appellant before us for the first time cannot be considered in this appeal, since this point appears to have been not urged before the learned single bench, though it is stated that a specific pleading has been made to the said effect in the writ petition. Therefore, the only remedy available to the appellant is to file a review before the learned single bench and canvass the other grounds which have been raised in the writ petition. Full stop. For the above reasons, the appeal stands disposed of, giving liberty to the appellant to raise all contentions except the contention with regard to whether approval is obtained from the specified authority or not. If such review application is filed, the learned single bench is requested to consider the other points which may be urged by the appellant in the said review application. Appeal stands disposed of. Next. No, Shankar Singh from Paris.
Serial number 5.
Lordship, in item number 5, I'm praying for just not today, Lordship.
Why, Aishwarya?
Your Lordship, Mr. Shiv Shankar Banerjee is appearing.
It's not there, used.
Your Lordship, actually, I have filed this appeal, Your Lordship, but there is one problem. This appeal has been allotted to Ms. Mansi Mukherjee now, Your Lordship, and the complete record has been transferred to her, Your Lordship. So, yeah.
And
actually, this was her appeal only, Your Lordship, but due to certain period of
e-way bill expired only 3 hours. There's a difference.
Yes.
Therefore, the learned single bench says and who will be appearing for the appellant now?
Lordship, Ms. Mansi Mukherjee and Shiv Shankar Banerjee, they are appearing.
But you filed the appeal, now the file has gone back to
Your Lordship, this file was actually with Mansi Mukherjee, but due to some medical emergency, for some period of time, she was not available, Your Lordship. So the department requested.
When do you want it?
Your Lordship, just not today, Your Lordship.
Not today.
I'm grateful, Your Lordship.
Serial number 6.
Well, I'm for the petitioner. Appellant, my lord. My lord, what happened in this case, my lord, we have specifically, after 148 AD order, we have specifically asked for the crop. They have issued the show cause notice, wherein they have first statement that there's one Mukesh Banka has made a statement. We have asked for the cross-examination of the person. But subsequently, they have issued the link, provided us to appear before the link. But they have issued the link on 9th of May, asked me to appear on 12:15 p.m. But they have issued the letter on 12:36 p.m. Subsequently, they have once again we have filed a reply. They said we could not appear due to that fact, that we have received the link after the hearing is over. Again they have sent the notice link, but Mukesh Banka didn't appear. Then he said on 11th May, they said that he did not appear, so that we cannot give the further cross-examination. They have passed the assessment around 24th of May 2023, my lord. Well, kindly see the assessment order at page 106. Kindly come to page 138.
Well, one wrong fact has been recorded in the of the last part, my lord, page 138. Para 2, my lord.
But Mr. Dutt, if suppose he doesn't respond to the summons,
Yes.
the department is not powerless. No? It can summon him. They can do.
Millard, the first notice was given to him when they did not appear.
Yeah, that
The
in
second
fact, the learned judge has recorded that.
Yes, Millard, the second notice was given on which the witness did not appear.
So therefore, the
So,
department say, first of all, you could have done two things. Request for cross-examination could have been rejected at the first instance,
no, only,
but they granted it.
yes,
But some link was not shared, etc. Second time when the link was shared, that fellow did not appear.
yes.
And thereafter he said, for health reasons, I am not able to appear. Then the assessing officer says it's getting time barred on 31st May. Therefore, I will not provide. That is wrong.
No,
We will extend the time.
he did not look into the statements made by the witness while passing the assessing officer.
No, correct,
Order.
sir. First, if you had
He does not rely on the statements, Miller, and he relies on other documents which are on record. Then, Miller,
then you do one thing. Then you pass a fresh order. You eschew the statement of Mukesh Banka.
Yes.
But what the officer says is, the statement of Mukesh Banka was recorded on oath on 35-19-7, which are very much clear in respect of the modus operandi. So they proceed based on his statement.
yes,
If
kindly
he-
see paragraph,
Yes,
the
sir.
second paragraph at page 138, last line. Page 138, last line. The second paragraph, last line. Asked on the completed on the basis of material on record.
Is material,
Not
what is
the
the material?
statements.
No.
Material,
You see paragraph 2 of that order.
page 130.
Para 2.
The last sentence, Miller, makes it clear that
No, my lord.
basis of the available record.
You read 4 or 5 sentences above that.
The statement of Mukesh Banka was recorded
On
oath on 3rd
sentence
of May.
starting about 1, 2, 3, 4, 5 lines from the bottom. The statement of Mukesh Banka was recorded on oath on 35 and 19-7, which are very much clear in respect of modus operandi. So we will say that without relying upon Mukesh Banka's statement, based on the available record, give him an opportunity of personal hearing,
Yes.
redo
And
them.
finish up.
Yes.
Yes.
This intra-court appeal by the writ petitioner is directed against the order dated 16th August 2023 in WPA 186-83 of 2023. In the said writ petition, the appellant had challenged the assessment order dated 24th May 2017 under section 147 read with section 144 capital B of the Income Tax Act 1961, within bracket the Act, for the assessment year 2017-18 on the ground that the appellant had not been granted an opportunity to cross-examine one Mukesh Banka, whose B-A-N-K, Mukesh Banka, whose statement was recorded under section 131 of the Act. The learned single bench, after noting the observations made in paragraph 2 of the order passed by the assessing officer, has dismissed the writ petition. Aggrieved by the same, the appellant has appeared before this. Appellant has filed the present appeal. We have elaborately heard the learned advocates for the parties. Admittedly, the request made by the assessee for cross-examination of Mukesh Banka was accepted by the department, and summons was issued to the said person to appear online on 10th May 2023, and the hearing was fixed at 12:15 p.m. No,
9th of May, my lord.
11th of May 2023, and the hearing was fixed at 12:15 p.m.
Was my lord 9th May. 9th May, it was fixed on 9th May, 12:15 p.m.
No, but you see 138 page, it says.
My lord, page 99 of the stay application, my lord, kindly see. It is
No,
recorded.
the order impugned.
But it is wrongly recorded. My lord. Two parts has been wrongly recorded, my lord. In the notice, it says 9th of May 2023.
So
It
to
was
appear
wrongly
on
recorded.
9th of May
Oh.
2023, and the hearing was fixed at 12:15 p.m. on the said date.
Yes, my lord. In the show,
It is the
shows from
case of the assessee that the link for attending the hearing through video conferencing was shared with the assessee much after the time which was fixed.
Yes, my lord.
Consequently, the assessee could not avail the opportunity. This was brought to the notice of the assessing officer by way of a representation. The assessing officer accepted the same and fixed a fresh date for cross-examination of the said Mukesh Banka, and the link was shared. On the date so fixed, the assessee appeared online. However, Mukesh Banka did not turn up, citing certain health reasons. Once again, the assessee had made a request that Mukesh Banka be produced for cross-examination, and thereafter the assessee should be granted an opportunity to put forth their case. However, the assessing officer declined to consider the said request on the ground that the assessment proceedings are getting time barred on 31/5/2023, and proceeded to state that the statement of Mukesh Banka was recorded on oath on 30/5/18 and 19/7/18, and they are very much clear in respect of modus operandi to provide accommodation entries. Thus, the assessing officer proceeded on the basis of the statements recorded for Mukesh Banka without affording an opportunity to cross-examine the said person by the assessee. It would have been a different case had the department rejected the request for cross-examination at the first instance, and the matter would have been dealt with in a different manner by the assessee. However, the request made by the assessee for cross-examination was considered and granted. And merely because Mukesh Banka refused to cooperate with the department by responding to the summons cannot prejudice the assessee. And simultaneously, the assessing officer cannot proceed on the basis of the statements recorded by the from Mukesh Banka, which remains uncontroverted. There are two ways by which the department can resolve the issue. Firstly, by issuing fresh summons to Mukesh Banka and fixing a fresh date for cross-examination. Or the second methodology that can be adopted is to ignore the statements recorded by Mukesh Banka, afford a fresh opportunity to the assessee by way of a personal hearing through video conferencing or in person, and thereafter consider the materials placed by the assessee and proceed to take a decision in accordance with law. Therefore, by not providing an opportunity to cross-examine Mukesh Banka, the authority is precluded from relying upon those statements recorded from the said person. For the above reason, we are inclined to interfere with the order impugned in the writ petition dated 24th May 2023. Accordingly, the appeal is allowed. The order passed in the writ petition is set aside, and consequently, the order of assessment order dated 24th May 2023 is set aside, and the matter stands remanded to the assessing officer for fresh consideration. The assessing officer is directed to issue fresh summons to Mukesh Banka and ensure his presence and permit the appellant to cross-examine the said person, and thereafter afford an opportunity to the assessee to submit additional reply and take a final decision in the matter in accordance with law. In the event Mukesh Banka refuses to cooperate with the department by not responding to the summons, then the department cannot rely upon the statements recorded from Mukesh Banka, and a fresh decision be taken by the assessing officer after affording an opportunity of fresh hearing to the appellant and take a decision based on the materials available on record, except the statements of Mukesh Banka.
Grateful, my lord.
Next.
Serial number 7. Please, Lordship.
Yes, sir.
Well, I'm led by Mr. Goel.
Yes. Yes, Mr. Goel.
So grateful, Lordship. My lords, good morning. My lords, this is the writ petition, my lords, writ appeal. We are challenging, my lords, why I'm before. My main plea would be, my lords, that there is violation of principle, serious violation of principle of natural justice, my lords. When the assessment was framed under section 143, my lords, in that assessment, my lords may note, my lords, I will take you to the assessment order in annexure, and my lords can have page number 88 onwards. This assessment order, my lords, is primarily based on one statement of one Mr. Neeraj Singh, my lords. If my lords have with me page 88, your lordship. I'm there, your lordship?
Yes.
My lords, this is the assessment order dated 31st March 2023, which was passed under section 147 after 148A. Now, my lords can have page 91 onwards. Page 91 onwards, my lords, first time in the assessment order, I will show from the assessment order only, my lords, without any show cause notice on this statement, without any statement being provided, the statement has been first time included in the assessment order. It goes from page 91, my lords. This Neeraj Singh statement goes till, my lords, page 96. Now, my lords can have show cause notice, your lordship, which is reproduced from page 96. There is no trace of Neeraj Singh's statement in the show cause notice dated 10th March 2023, my lords.
No, sorry for interruption, Mr. Goel.
No, sorry, my lords, I'm sorry.
The learned judge says that you have impugned the order of transfer under 127.
I challenge, my lords, I bow down. What I did, my lords, I challenged two actions of the revenue, my lords. I'm so grateful. One was 127, which was passed prior to this assessment and after 148A. Now, when the honorable judge said, my lords, I was myself appearing, I said, I'm not mainly on 127, I'm mainly on violation of natural justice in the final assessment, because why, my lords, there is no personal hearing given to us, there is no back material provided to me. So the assessment order travels beyond the show cause notice, includes something which was never there in the show cause notice, and I'm left like this, that, my lords, in 148 also this was not there. So I should be given material, and I am not also given cross-examination. What to talk about cross-examination? I have now kindly see, my lords, my reply, which is reproduced in the assessment order, my lord. I will just take you to that reply main part, my lord. Kindly have your lordship page 101 onwards, my lord, where the reply in the assessment order is reproduced. I will show from the assessment order on page 101.
Yes.
My lords, I'm so grateful to quote. My lords, kindly have page 103. If I'm there, your lordship, this page 103, above point number 6, my lords, we have said you have relied on the alleged incriminating documents found. I'm there, my lords, with your lordship.
Yes.
So grateful, my lord. You have relied on the alleged incriminating documents found during the search operation and statement of Anup Maji and Anjani Kumar. These two statements were only there in the statement, in the show cause, my lords, and that too extract was there only. No statement was provided. However, you have not provided any such alleged incrimination documents or copy or statement relied by you. You are therefore requested to provide copy of the incriminating documents so and so. Though you have reproduced certain portion of statement of the above person in which they have admitted of coal sale in cash, but nowhere the name of our company is found. All your allegations are based on wild guess. It is the duty of the department to put before the assessee the materials gathered behind its back for rebuttal. You are therefore kindly requested to provide the copy of the incriminating documents, copy of the statements relied by you, and opportunity of cross-examination should be allowed. My lords, may I have the next page of my reply, page where last 3 lines, my lord. These are very critical. If I'm there, in case you want to take any adverse view, I'm there, your lordship, on these lines.
Yes.
In case you want to take any adverse view, you are requested to provide us copy of the material, A, opportunity of cross-examination, B, C, personal hearing. Now, my lords, nothing of this has been given to me. And this order has been passed in flagrant violation. And kindly see, my lords, in 148 AD order, although I'm not on 148 AD, but in 148 AD, none of these statements, none of these things was in picture. It all came in show cause notice, which is passed, which is just given to me prior to this assessment, and where no material was enclosed. Only some loose extracts, 2 or 3 lines were given, my lord. How can I reply?
And who will appear for the department? Smita Das has appeared.
I think, my lord. I have some filer affidavit service, my lord. So we have served.
Smita is not here today.
In court number 2.
We'll pass over the matter. We'll,
I'm so grateful. So grateful.
We are told Smita Das is in court number 2. She'll come.
My lords, my lords.
Short
So,
pass over.
my lords.
And I'm for the appellant, my lord. My lord, I'm praying for 1 week time, my lord, because we could not file a stay application to the, we have filed a memo only, my lord, because the deponent is out of, he's not able to come to file a stay application, my lord. What is this?
And what was the interim order you sought for?
Basically, my lord, with the assessment year 16-17, the alleged escapement of income is below 50 lakhs. But if they more than 3 years, when if the alleged escapement is less than 50 lakhs, they cannot issue the 148 notice in view of the new amendment made in 2021. If it is more than 50 lakhs, then only they can issue the 148 notice. And, no, my lord,
Yes, ma'am.
item
Sit down, sit down.
Item number 7.
No, what was the interim order you sought for? Was there any recovery proceedings?
No, this is only 148 AD, my lord. 148 AD and 148.
The learned judge says, heard the learned advocates, I am of the view, there is no scope for passing interim order at present.
No, we have challenged the 148 AD order and 148 notice only. Only.
So
recovery proceeding will come only after the assessment only. They cannot make an assessment only.
Is there a threat that they will pass the assessment order? Where is the Pratudoria?
2000. There must be, sir, my lord, because 148 AD was passed in July 30, 2022. So that is when.
When the matter was directed to be listed in August, it is not listed. Affidavits have not been filed.
They have not filed any. Till date, they have not filed.
Smita, where is Pratudoria is not attending court?
He's before court number 2, my lord. He's on his legs.
See, they have challenged 148 AD and 148 notice.
Yes, my lord.
Till now, the department has not filed their affidavit in opposition. Writ petition is pending since June 2023, though fixed for August, not taken up. Meantime, if you pass an assessment order, then he'll have to file a supplementary affidavit, bring that on record. So then don't proceed to pass. You file your affidavit within 3 weeks or so. In the and we'll direct the matter to be.
I shall convey Mr. Bhuturia with regard to the filing of his affidavit.
By the writ petitioner is directed against an order dated 5/6/2023, by which the learned single bench declined to grant interim order and directed the respondent department to file their affidavit in opposition within 4 weeks. And appellant was permitted to file the reply within 2 weeks thereafter. And the matter was directed to be listed in the monthly list of August 2023. We are informed by the learned advocate for the appellant that till date the department has not filed their affidavit in opposition, though 4 weeks time was granted in the order dated 5/6/2023. Thus, we are of the view that if during the pendency of the writ petition, without complying with the direction issued by the learned writ court, by filing and filing an affidavit in opposition, if the department proceed to pass a reassessment order, then the challenge to the proceedings initiated under section 148 capital A within bracket small d of the Income Tax Act 1961 is liable to become may become infructuous. Therefore, we direct that the respondent department shall not pass the reassessment order till the writ petition is heard. The respondent department, the time for filing affidavit in opposition as granted by the learned writ court is extended by a period of 4 weeks from date. Reply, if any, within a week thereafter, and the writ petition be listed in the before the appropriate bench on 6th of February 2024. What we have said is, don't pass reassessment order. From June, the matter is pending. You have not filed your affidavit. We extended time for filing. We said don't pass reassessment. Yes, call the passover matter.
Serial number 7.
Smita, you are ready in this matter?
May please,
Just now I have received the brief, my lord. I was not aware of it.
Mr. Goyal will say not today. Let madam go through the papers.
my lord.
Yes. Item 7, not today.
Yes.
Grateful.
Serial number 9.
Well, I am for the petition, my lord.
Yes.
My lord, the appeal is filed delayed. There is a delay of 81 days, my lord. And it has been explained in the
That we can condone.
81 days, 1 day delay, my lord. We want to file affidavit. My lord, they always prayed for. When we pray, they always prayed for.
My lord, it is an aptly the petition was the writ was
What was challenged? What is the 25th July order?
my lord.
What
My
is
lord,
the
page number 88, my lord, of the
petition?
state petition, my lord.
Page 88. No, that is the order passed by the learned single bench.
My lord.
What was the order impugned in the writ petition?
My lord, the order impugned in the writ petition was disallowance of the refund application which I made, my lord. My lord, and which was against the principle of natural justice, my lord. My lord, lordship.
Let us see that order.
My lord, I'll take 2 minutes of your lordship, my lord.
25th July.
My lord. My lord, lordship comes down to my lord, page number 21, my lord. The stay. Come, my lord.
Reason for refund, excess payment of tax.
This was the application made, my lord.
Application for refund.
My lord. My lord, I had filed the returns, my lord. Subsequently, under section 44, an annual return was filed. In the annual return, certain excess payment was made, my lord. For that, my lord, I had filed an application for a refund, my lord. My lord, thereafter, lordship, it comes down to my lord, page number 8, my lord. 27, my lord. Sorry, my lord.
27.
27. This is RFD 08, which is the so-called notice, my lord. In the middle, my lord, delay in filing application, my lord, lordship gets it, my lord. My lord, this was the reason, my lord. The so-called was on the delay in filing the application. My lord, I gave a reply. But unfortunately, my lord, fortunately, I have in page number 28, my lord, the copy of the checklist which was prepared by them as per CBIC, my lord, which is required to be prepared by them. Lordship, it comes down to page number 28, my lord, and serial number D. My lord, in the right-hand side, my lord, the claim is not time barred as per section 54(1), read with explanation, this. My lord, thereafter, my lord, in G, my lord, the claim is time barred. My lord, SCN contents, my lord.
Whether any show cause notice was issued or plain details are replied.
It was.
The
Well, the
claim
reply
is
was to
time
be
barred.
given by 14/6/21, my lord. What is, my lord? In serial number G, my lord.
Yes.
Well, in serial number G, the claim is time barred as per section 54(1), read with explanation this, and reply to be given by 14/6/21, my lord.
Very good.
My lord, thereafter, my lord, the reply contents is the Honorable Supreme Court order dated, my lord, order number 21 of which this was replied, my lord. The next page, my lord. Now the next page, my lord, serial number H, my lord. Discussion and finding in respect of the applicant submission, my lord. The claim is not time barred, number 1. Number 2, the claimant did not show the excess payment in either monthly return or GSTN 3B or annual return, that is GSTN 9, my lord. My lord, these are all cropping up, my lord, for the first time, my lord. Not in the so-called notice.
Yes, Mr. Mighty.
My lord, so-called notice along with this checklist has been given. My lord, your lordship will kindly
You
appreciate
see the
only
show cause notice, delay in refund application.
delay in refund of application. Subject to that, my lord, there are
Now
some
you
other.
have given up that point, and you say that he has not shown it that in the monthly return that is GSTR 3B, but he says in the annual return GSTR 9 he has shown it.
My lord, so-called notice has been issued only on the contents that delay in refund. But thereafter, when the checklist has been...
Why you didn't appear for the personal hearing?
Yes,
my lord.
He didn't appear.
My lord,
Not attended the PH.
Page number, my lord, 32, my lord.
What is 32?
My lord, request for adjournment of personal hearing and or extension of date of replying to SCN, my lord.
On what date this request was uploaded?
On 14, my lord. On 14 itself.
Where do you get the date?
My lord, in the middle, my lord, serial number 3, extension adjournment request date, 14/6/22, my lord.
14/6. On what date you made this request?
My lord, the
What
date
date it
was
was uploaded?
That is on 14/6,
14/6, my lord.
on the same date.
On the very same date, my lord. And my lord, what has come?
Now you show
Yes.
where you have shown this in your annual return.
Well, I have not annexed the annual return, but my lord, the
One more opportunity.
yes, my lord, but I am seeking
You
one
have
more
given up the
opportunity.
reason for delay because of Supreme Court order, and he says claim is not time barred under 54(1), read with explanation 2H of the CGST Act. That point you have accepted. Now you are denying his claim on the ground that he did not show this excess payment either in the monthly return or in the annual return. But his case is in the annual return he has shown.
He's saying, well, he is
established
My
before
lord,
the
if
authority.
I'll go out of the my application will be no.
So, my lord, kindly direct the adjudicating authority to hear the matter, and if they want to file the reply to the same within certain time period, my lord, to that extent, my lord.
This intra-court appeal by the writ petitioner is directed against the order dated.
My lord, first the delay may be condoned.
Oh, delay.
My lord.
In the earlier matter, Pranit Park appeared. There is a delay of 26 days. That has to be condoned. Two, I think, not three.
My lord, may I take your lordship?
Yes. We have heard so and so. There is a delay of so and so days in filing the appeal. We have perused the application and we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Accordingly, can number 2 of 2023 is allowed and the delay in filing the appeal is condoned. 81 days. Sir. This intra-court appeal by the writ petitioner is directed against the order dated 28 March 2023 in WPA 5664 of 2023. In the said writ petition, the appellant had challenged the order dated 25th July 2022, by which the application filed by the appellant for refund of excess tax paid was rejected. The learned single bench had dismissed the writ petition. On the ground that the claim for refund was rejected on on certain other grounds, and if the appellant is agreed, he has to avail the alternate remedy available under the CGST Act. Aggrieved by such order, the appellant has filed the present appeal. As could be seen from the show cause notice dated 7/6/2022 in form GST -RFD-08. It is in page 2. The appellant was directed to show cause as to how the refund application was within time. The appellant submitted the reply on contending that as per the order passed by the Honorable Supreme Court, the limitation period of 90 days starts from 1st March 2022 and the application for refund has been filed within time. Further, the appellant placed reliance on the decision of the High Court of Madras in GNC Infra LL versus Assistant Commissioner and the decision of the High Court of Bombay in Sahir Supply Chain Company versus UOI. It is on page 29. The authority, while rejecting the application, appears to have been convinced that the appellant is entitled to the benefit of the order passed by the Honorable Supreme Court by which the period of limitation under the various statutes stood extended. However, the claim was rejected on a new ground, which was not forming part of the show cause notice dated 7/6/2022, stating that the appellant has not shown the excess payment in either the monthly return, that is GSTR 3B, or annual return, that is GSTR 9, numerical 9. This ground appears to have not been specifically mentioned in the show cause notice dated 7/6/2022, and therefore the rejection of the application for claim for refund on the said ground is in total violation of the principles of natural justice. That apart, the appellant had also made a request for postponing the personal hearing by adjournment request dated 14/6/2022, which has also not been considered. Therefore, we are of the view that the application for refund made by the appellant has to be reconsidered in accordance with law after affording an opportunity to the appellant. For the above reasons, the appeal is allowed, order passed and the writ petition is set aside, and the writ petition is allowed, and the order of rejection dated rejection of the refund application dated 25th July 2022 is set aside, and the matter stands remanded to the authority for fresh consideration. The authority shall afford an opportunity of the appellant is directed to submit the reply to the allegation that they have not shown the excess payment either in the monthly return or in the annual return, and such reply shall be filed within 15 days from the date of receipt of the server copy of this order. On receipt of the reply, the authority is directed to fix a fresh date for personal hearing, and after hearing the appellant or its authorized representative, pass fresh orders on merits and in accordance with law. So far as the contention that the refund application is time barred is concerned, the said issue having been held in favor of the assessee, appellant assessee, the same cannot be reopened by the authority based on this order.
Serial number 10.
Yes. Yes, sir. Chatterjee, what is this?
Lordship, in this matter, Your Lordship, I have not filed the stay application. Your Lordship has not been filed, Your Lordship.
And what was your writ petition for?
Writ petition is, Lordship, cancellation of the revocation of the cancellation of a registration, Your Lordship. I had given the copy. My registration was cancelled under GST. My registration was cancelled.
Reason?
Lordship?
Reason for cancellation?
For not being present at the place of business.
It was found locked.
Then I filed a revocation of cancellation of registration. Now I gave a copy of an agreement with the previous owner. Now occupancy agreement with the present owner, as well as trade license and electricity documents. Now they have considered that the electricity document is not mine, does not tally with my name.
No, electricity connection will stand in the owner's name.
Owner's name, Your Lordship. And the previous owner also has died before the agreement was inked. But my question, Your Lordship, the later agreement, Your Lordship, was there. Later agreement of occupancy agreement. They have not considered that.
Now show that order rejecting your application for revocation.
Lordship, this.
That was impugned in the writ petition.
Lordship, that was impugned. Page 53 to 55, Your Lordship, kindly. 3 to 55.
But the learned judge has directed affidavit to be filed.
Affidavit in opposition. Page 55, Your Lordship, that was taken into consideration. Because.
And who will appear for the respondent?
State has to appear, Your Lordship. I have not served. I have not served upon the state.
All right. List the matter next week in the admission list to enable the appellant to file the stay application. Advance copy be served on Mr. T.M. Siddiqui, State Council. Next.
Serial number 11.
I am for the petition, my lord, against cancellation.
I appear for the state response.
Or come before Lordship, my lord, against cancellation of registration, my lord. Lord, I am the owner of the property from which I conduct my business. My lord, sometime in 4th of January 21, my lord, the department, my lord, they go to my premises, my lord, to verify. My lord, in page number 13, my lord.
31.
13,
30.
1-3.
Hmm.
My lord, I am at that very moment, I am not present over there. My son, my lord, who is a student, my lord, engineering student, my lord, during COVID, my lord, he was at home, my lord. He studies outside West Bengal, my lord. Now, my lord, second paragraph. After reaching the place, I find 13, my lord. After reaching the place, I find the residence of Pravir Karnar, proprietor of Karnar Engineering Works. I find no signboard, my lord. Board maintaining the name and address of the RTP. Then I asked the door knocked the door repeatedly, and after 15 minutes, a young boy appears before us and introduces himself to be son of Pravir Karmakar. Then we disclose our identity and purpose of the visit. Hearing that, he says nothing about business activity of the RTP on behalf of his father, that is Pravir Karmakar. But my son, my lord, I'm practicing law, my lord. My son is doing engineering, my lord. How come he knows that what I am doing, my lord?
No, there should be at least some board, some
my lord,
semblance of activity.
Definitely, my lord.
Well, a lawyer's office, some at least 10, 15 books you should have. You should have a table. You should have a chair. 3 chairs for your clients.
My lord,
your clerk. You will have to have one system. Basic requirement.
My lord, basic requirement, excepting the board, my lord. Everything was over there, excepting the board.
No, the officer says no sign of loading, unloading. What was
my lord, loading,
unloading? Engineering works.
My lord, it is engineering works. He get the job. It is by job work, my lord, to the company, my lord, who is supplying to Jamshedpur, my lord, the Tata Engineering, my lord. Telco, he is supplying to the job, the agent.
All right. Now, they say registration obtained by fraud.
My lord, 15, my lord. Page number 15, my lord. The so-cause notice, my lord. The registration has been obtained by means of fraud, willful misstatement, and suppression of fact, my lord. How can this be? How can this be, my lord?
No, at least you could have produced thereafter, gone before the officer,
my lord,
produce some documents like invoices, your income tax returns,
my lord,
any other document to prove that you have paid any service tax or any GST.
Lord, it was not a case whereof I did not file my returns. It was not a case whereof my taxes was not paid, my lord. It was not a case that there was an allegation against me that my purchases were from fake parties, my lord. It was, my lord, in page number 16, my lord. In fact, my lord, the Panchayat corporation tax, my lord, against my property, which I have paid, my lord, of 1,40,000 has been annexed. It is my property, my lord. And thereafter, in page number 17, my lord, lordship comes
to. You didn't respond to the show cause notice.
My lord, I could, my lord, he is a totally illiterate, class 4 passed out. He's a class 4 passed out, my lord.
That is
I admit it, my lord.
Successful
My lord, I admit it, but my lord, on this reason, can it be stated that I have, due to
what to do, sir? What can the officer do if you are not able to produce records? You didn't appear, you didn't show cause, you didn't reply to the show cause notice.
My lord, in that case, my lord, lordship allows me one opportunity, my lord, so that I can go and produce.
No, instead of that, no use going before the same officer.
My lord,
you file an appeal.
Well, I filed an appeal. I filed an appeal.
Appeal also twice he did not appear.
My lord, appeal was rejected on the grounds,
Page
my lord.
26.
Page number 27, my lord, the operational part of the
26.
order, my lord. It is on different grounds.
Appeal is also, my lord, ex parte order. He did not appear. Twice opportunities were given.
But 27, my lord, the operational part of the order. So the learned assistant commissioner state tax Shibpur charge is a responsible.
No, then he is not a diligent.
My lord, it is online, my lord. Lordship kindly considers it, my lord. It is not comfortable. It is not easy for everyone, my lord, to get into the portal and check it out, my lord, every time.
What is his turnover?
My lord, I have to get the instruction, my lord, in that case.
He should be able
to. My lord, it is, my lord, again, my lord, my prayer
is something like running away from the problem. And ultimately, he is
it is no, otherwise I wouldn't have come before your lordship, my lord. If I was running away from the problem, my lord, I wouldn't have come before your lordship, my lord.
Yeah, all right. Why can't we give one more opportunity
before the appellate? But this time, my lord, he should not seek any adjournment and should appear.
Otherwise, we'll make that clear. This intra-court appeal is directed against an order passed by the learned single bench, dated 29th August 2023 in WPA 20381 of 2023, by which the prayer for interim relief was rejected. The writ petition is still pending, and affidavit in opposition was directed to be filed by the department. As jointly prayed, the writ petition along with this appeal are taken up for disposal by this common order. The appellant had impugned an order passed by the appellate authority, namely the Senior Joint Commissioner of WBGST, Howrah Circle, dated 26th August 2021, by which the appeal petition filed by the appellant challenging the order passed by the Assistant Commissioner of State Tax, Shibpur Charge, Howrah, rejecting the order, rejecting the application for revocation of the order cancelling the appellant's registration. As could be seen from the order passed by the appellate authority dated 26/8/2021, the appellant failed to appear before the appellate authority despite notice being served on the appellant. The appellate authority has also noted that the appellant did not reply to the notice dated 16/3/2021 issued by the assessing authority. Thus, it is seen that the appellant has not been diligent in prosecuting the matter either before the original authority or before the appellate authority, and consequently he has to reap the consequences. The learned advocate appearing for the appellant would plead that the appellant is not well educated and is not very conversant with uploading of details electronically before in the official portal, etc., and prays that one more opportunity may be granted to the appellant to go before the appellate authority and place all documents to establish that the appellant is carrying on business in the place in question and that the registration certificate has not been obtained by playing any fraud. Full stop. Considering the peculiar facts and circumstances of the case, we are of the view that one more opportunity can be granted to the appellant, and this shall appellant to go before the appellate authority, and this shall be the final opportunity. And if the appellant fails to utilize this opportunity, then no relief can be granted to the appellant. For the above reasons, the appeal and the writ petition are disposed of by remanding the matter back to the appellate authority with a direction to recall the order dated 26/8/2021, grant 15 days time to the appellant to file their reply to their objections/reply, and after which a fresh date for personal hearing be fixed, and after hearing the appellant or his authorized representative, fresh orders be passed by the appellate authority on merits and in accordance with law. Next.
Grateful. Grateful.
Serial number 12.
Tapan Banja.
Yes,
sir.
13 our application, our appeal, my lord. This matter, my lord, we need to file stay application. Also, my lord, 2 other appeals also required because subsequent 2 orders have been passed by subsequent 2 honorable judges, my lord. That's why, my lord, that appeal also required to be filed. We applied, but we couldn't get hold of the, my lord, certified copy. There is a case, my lord, they come with they challenge an order original in a pending CAN application in the writ petition by filing a supplementary affidavit. My lord, the trial court directed the authority to pass an order in respect of recovery of the cost recovery charges, my lord. Your lordship knows of the ICD, my lord. Yes. Now, my lord, they have paid up to 31st January 2023. During that time, the honorable court directed that you please decide this issue. Other 2 issues are pending now in the writ court. Now, my lord, the commissioner decided it. My lord, they come with an CAN application earlier in 2022. Order passed in February 2023. Now, my lord, subsequently, my lord, they come with a supplementary affidavit in a CAN challenging the order in original, which is applicable under section 129 capital A. My lord, that is the new cause of action. Well, that is the subject matter of challenge.
Oh, the learned judge has not allowed the CAN application, but directed you to file your affidavit. You raised this objection regarding maintainability of this supplementary affidavit.
My lord, I have
Status quo order has been
status quo
passed.
order has been passed. But now, my lord, what he is doing? They are realizing money from the public. The customers who are attending the ICD, they are realizing the money, didn't pay the exchequer to the government. Well, very funny thing is going on. Government money, they are realizing they do not give the government money to the government. My officers are posted there.
Correct.
Your lordship knows that I have to pay them.
You withdraw those officers or cancel his license.
No, now, my lord, now
Status
that has been
quo
for the
status
benefit
quo
of the
order has
public, it has been done. Well, for the benefit of the public, well, for the customers, it has been created. Now, my lord, status quo order is done, my lord, passed by the learned trial court, my lord. It is now continuing.
No, what is the order dated 13th July 2023?
13th July, my lord, we have issued notice asking them, please give us the cost recovery charges. My lord, the trial court, and the day when the order was passed, 28th July, your lordship knows, my lord, there is no CAN application. There is no order, there is no notice, nothing. It was not the part of the record when the order was passed. But they simply show a letter which has been issued by me, my lord. This shows that, see.
All right. When you file the stay application.
My lord, my lord.
When do you want it?
10 days, my lord.
10 days.
Both, my lord, both items.
All right. List the matter at the request of the learned advocates for the appellant. Both item 12 and 13 listed on 16th January.
Grateful, man.
In the same position.
Grateful, man.
Real number 14.
There's a delay of 184 days, my lord. It was served, my lord. The affidavit services got ready before the trial court. Mr. Abro Mujumdar appeared, my lord. So I have requested him.
Where is it?
Lord, before trial court, I find Mr. Abro.
No, he was here now.
I have given it to him, but he returned it on the ground that again you serve because he may not be appointed by the. Well, let him. That is. I'm sorry, my lord.
He can run away.
I'll just hand it over. Well, here actually, what actually happened, my lord? Here the learned trial judge, my lord, dismissed on the ground that the draft assessment order was not given. My lord, on this ground, my lord, he said that the draft assessment is a mandatory. But not the in my lord, the section doesn't say that it's mandatory. My lord, final assessment order was given and they have participated. Everything has been done. But now at the stage, they are saying the draft assessment order was not given. Therefore, you again give draft assessment order. That was the order passed by the learned single judge. My lord, that was the subject matter of challenge before your lordship, my lord. And my lord, again. Regarding one
but the matter has been sent back to the authority. Why delay the matter? Otherwise, it will be hanging here. He has not filed an appeal. He has not filed an appeal against the remand order.
No, but the trial, the learned single judge has remanded the matter back to the authority concerned.
Correct.
For purpose of, again giving this draft assessment. That was subject matter of challenge before, because that.
But
in their SOP, my lord, they are saying that it's not mandatory because final assessment order they have participated everything. Now they are at this stage they are saying that draft assessment has not been. Lordship will kindly seize the learned single judge order, my lord. Subject to lordship kind consideration. But it's in my lord the memo appeal, and before the my lord, lordship will kindly seize.
No. Your contention is
yes.
He was issued with a show cause notice dated March 7th,
yes,
which is in the nature of a draft.
Yes, but that was our contention.
That
is a subject.
How many days delay?
184 days, my lord.
I heard Mr. Prithidorial and Senior Standing Counsel for the appellant and Mr. Avra Mazmundar and an advocate appearing for the respondent writ petitioner. There is a delay of 184 days in filing the appeal. We have perused the application and we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Accordingly, CAN 2 of 2023 is allowed and delay in filing the appeal has been condoned. This intra-court appeal by the department is directed against the order dated 16th May 2023 in WPA 8122 of 2023. In the said writ petition, the respondent herein had challenged the order passed under section 147, read with section 144 capital B of the Income Tax Act 1961, dated 20th March 2023 for the assessment year 2018-19, on the ground that no draft assessment order was served on the appellant, on the writ petitioner, before final assessment order was passed. It is a submission of the learned senior standing counsel for the appellant that it is not mandatory for the officer to serve the draft assessment order. However, from the memorandum of appeal, we find that the contention of the department is that the assessing officer had issued show cause notice to the assessee on March the 7th, 2023, which is in the nature of a draft assessment order containing all proposed variations. If that be so, if this is the stand taken by the department, it goes without saying that there was no draft assessment order prepared, but only a show cause notice was issued on March 7, 2023. Thus, we are of the view that the learned single bench rightly set aside the assessment order and remanded the matter back to the assessing officer to supply a copy of the draft assessment order, and thereafter, after inviting the objections from the assessee, proceed to pass final orders in accordance with law. Thus, we find no grounds to interfere with the order passed by the learned single bench. Next, dismiss.
Serial number 15.
Yes, Mr. Sen.
Your Lordship, your Lordship kindly takes up the matter tomorrow, Lord.
Tomorrow.
Fine. Only this accommodation.
Respondent, so Bhattacharya is here. Very big order.
Lord, to the best of my ability, I'll try to. Lord,
Not today.
I'm grateful.
Next.
Serial number 16.
Yes,
Lord,
Madhujana.
in this appeal, my lord, I have came here, my lord. Well, Mr. Siddiqui is on the side, my lord.
Where is Mr. Siddiqui?
Lord, in this matter, my lord, there is a delay of filing of GST return for 6 months, my lord. Due to my wife's chronic heart disease, my lord, I didn't, chronic liver disease that didn't appear in this matter, my lord. And somehow I have filed the appeal. There is a 4-month delay. I filed the appeal.
How many years? 1 year delay.
1 year delay. My lord.
He has got no power to condone.
My lord, he has nothing to.
And he has paid that 10%.
Yes, my lord, paid the 10%, my lord.
Where is the appellate authority's order?
My lord, I'll beseech my learned friend, my lord, I request my learned friend to serve me a copy of the stay application. I do not have any copies.
You will recollect, Mr. Siddiqui.
My lord, it's very difficult, my lord.
Without seeing the papers, you can recollect.
No, my lord.
At that point, right now, my lord.
No, you show the appellate authority's order.
My lord, order of the appellate, no, my lord. My lord, page 19, my lord.
19.
19. Order of rejection, my lord.
Correct order. As per the statute, he has got no power to condone.
All right, my lord, if that is happened, my lord, the petitioner right now, my lord, he is already, my lord, suffering from, I am not working, my lord. When he's
all right, this appeal was filed against which order?
Appeal is filed against, my lord.
That is at page 20, probably. Inspection carried out, residual place so and so invoices, seized documents, taxable commodity, mustard oil, refined oil, except books of account reveal that you have made outward intrastate supply of so and so 2 crores and odd under WBGST Act, rate of tax of 5%. Not issued any tax invoices against your outward supply.
Keep that phone number.
So 3,96,517 under CGST and same amount under SGST. Along with the interest and penalty.
Single bench key order.
Single bench.
Page 26 is the discharge summary of Subra Samanta. his
The wife
wife.
of the petitioner, my lord, I've annexed all the document at the point of time, my lord, he is not in the station also, my lord. There's nothing to do, my lord. He has
He'll
remained
send
in
it back
all-
to the.
My lord,
Otherwise, he
but,
is.
but my lord, I have to send it to the department. I request my lord friend to serve me a copy of the stay application of your copy. Your lordship may kindly send it back.
You give a copy.
Yes, my lord.
It does not have a copy.
My lord, I have already, my lord, I have already.
We'll give one of our copies.
No, my lord, today I have.
This intra-court appeal by
Achki.
the writ petitioner
Already,
is directed against the order dated
Department can also be. GP of
department is service.
36/2023 in WPA 144/70/2023, by which the writ petition filed by the appellant challenging an order passed by the Senior Joint Commissioner of State Tax, Kolkata North Circle and 24 Pargana Circle was dismissed. By the said order dated 18/4/2023, the appellate authority rejected the appellant's appeal petition on the ground that it is time barred. We have perused the said order dated 18/4/2023 and we find that there is no error in the said order, since the appellate authority cannot entertain an appeal beyond the time provided under subsection 1 of section 107 of the WB-GST Act 2017. The appellant, the learned advocate for the appellant would plead that the appellant appellant's wife was suffering from had severe medical complications, and the appellant had to attend upon her. And apart from that, the appellant had to take his wife to Vellore in Tamil Nadu state for treatment. Consequently, he was unable to be present in Kolkata. As a result of which, the appeal could not have been presented. So, appeal could not be filed within the period of limitation. It may be true that the period of limitation cannot be extended. But however, considering the peculiar facts and circumstances of the case, we are of the view that it will be better for the appellate authority to take a decision on merits, more particularly when the appellant has already effected the pre-deposit of 10% of the disputed tax. For the above reasons, the appeal and the writ petition stand disposed of by setting aside the order passed by the appellate authority dated 18/4/2023 with the direction to the appellate authority to entertain the appeal petition, afford an opportunity of personal hearing to the appellant or its authorized representative, and take a decision on merits and in accordance with the law. As mentioned earlier, this order has been passed considering the peculiar facts and circumstances of the case and shall not be treated as a precedent.
In the meantime, bank account may be open. Bank account, my lord.
The appellant is at liberty to seek for appropriate interim orders from the appellate authority with regard to the lifting of the attachment of the appellant's bank account. And if such application is filed, the appellate authority shall consider the same on merits. Next.
Serial number 17.
My lord.
Yes, Sweta.
My lord, I apologize, my lord, that service is not complete, my lord. I need a
And
time.
who will appear? Mr. Siddiqui will appear.
No, my lord, this is against the CGST authority. Mr. Maiti may appear, my lord, but they are not sure whether Mr. Maiti will be appointed or not, my lord. I shall come back after service, my lord, on the next week, my
And
lord.
what was the interim order you sought for?
My lord, the issue is that, my lord, I applied for a refund. The authority, without going through the documents and without any statutory power, my lord, my refund application, they issued the demand order in refund application without issuing any notice under section 73 and 74, my lord. And my lord, the main issue is that they are saying that I am supplying the products I am a manufacturer of vegetable oil, my lord. And there was a HSN code was wrongly mentioned in my GSTN portal, not in the invoices. So only on the based on that document they have
No, that's a very serious issue. No?
My lord, the
Rate of tax will differ.
No, my lord, I have uploaded the documents in along with my refund application. That 24 invoices were considered. Okay, fine, these are the since the rest of the invoices I could not upload, my lord, they have not allowed, my lord. And my lord, it has been ordered by the authority that in course of the verification, my lord, I have already applied for an amendment, my lord.
But then it's right, no, that we can't pass any interim order. Probably we can advance the date for filing the affidavit in opposition.
My lord, only thing is that, my lord, since they have issued a demand, my lord, in the refund application itself, my lord, which law does not permit, my lord.
Where, please show that.
My lord, page 50.
Page 163, he says no refund is.
My lord, no, my lord, the original order passed by the page 160 is, my lord, the appeal order, my lord. It's the original order in original starts from the page 11111, my lord. The order effective part of the order is at page 119, my lord. No proper show cause notice was issued, my lord. Therefore, based on the above discussion and finding, I hereby order that confirm the demand of such and such, my lord.
And there was no show cause notice?
No, my lord, because the show cause notice was under section 54, my lord. It was supposed to be in RFD 08, my lord. No show cause notice under section 73 and 74, my lord.
You show the appeal grounds. Where have you raised this contention?
My lord.
Page 160.
Yes, my lord.
No, you have not raised this point.
Yes, my lord. I have, my lord, in course of the appeal hearing also, my lord. I have submitted a reply to the appellate authority, my lord, in a written submission, in form of a written submission, my lord. My lord, which starts from page 133, my lord. 134, my lord. My lord, 135 is the.
No, you should have said that while considering your refund application,
yes,
simultaneously there cannot be a demand.
But my lord, what has happened against the show cause notice, my lord? There was a show cause notice in RFD 08, which was against the refund application, my lord. After the filing the reply against that show cause notice, a partial refund was accepted, my lord.
That is why the appellate authority has not gone into that aspect.
Yes, my lord.
You didn't raise this plea specifically. So what we'll say is, we will grant you liberty to file a scan application before single bench in the event a demand is raised.
My lord, the demand is raised, my lord, but no demand notice has been issued, my lord.
This intra-court appeal by the writ petitioner is directed against an order by which the learned single bench learned single bench observed that there is no scope for granting any interim order in the writ petition and directed affidavit in opposition to be filed by the department. We find there is no error in the said order, since as on date, no demand notice has been issued on the appellant by the authority concerned. The learned advocate for the appellant would contend that the authority, the original authority, while issuing a show cause notice on an application for refund filed by the appellant, had not mentioned anything about demand of tax, but in the final order, a demand of rupees 29,63,488 was made in terms of section 74 of the GST Act, along with appropriate interest thereon in terms of Section 50 of the Act. By the said order dated 30/11/2020, the Assistant Commissioner of Central Taxes, Kharagpur Division, had also simultaneously rejected the entire refund claim. When the order was tested before the appellate authority, namely the Joint Commissioner within bracket appeals, CGST and CX appeal to committee, Kolkata, we find that the order only deals with the correctness of the rejection of the refund claim. And there is no mention about anything with regard to the demand of tax of rupees 29,63,488. That apart, we note that till date no demand notice has been issued. Therefore, we dispose of this appeal, giving liberty to the appellant to file an application, a fresh stay application before the learned single bench, as and when a demand notice is issued by the respondent department. And if such application is filed, the learned single bench is requested to consider the same one.
My lord, the no affidavit till date they have filed, my lord. My lord, the factually is
time for filing affidavit in opposition, as granted by the learned single bench, stands extended by a period of 3 weeks from date, and reply, if any, within a week thereafter. Next.
Serial number 18.
Please, Your Lordship, I am filing the affidavit application today, Your Lordship. May I succinctly state the facts, Your Lordship?
Who will appear?
We appeared in the before the honorable single judge, and we have instruction, but we have not received any document.
I am filing
for
the
appeal
application
is
today, Your Lordship. May I just succinctly state the facts, Your Lordship? This Lordship, I have preferred the writ petition on 2 grounds, Your Lordship. One, non-receipt of the order, and another, Your Lordship, the hearing was fixed on 21st October 2022. And I received the communication to that effect. But from the communication of the order, the demand, it seems that the order was passed on 19th October 2022. The order was passed before.
Order is not physically served. It will be uploaded.
This has not been. I did not find, Your Lordship, this.
A copy of the order.
Order has
no, so they has produced before the respondent the relevant documents to show that the adjudication order was served on the appellant, and therefore the allegation of non-service is.
Lordship, one Rajesh Singh is there. The affixed in one Rajesh Singh. This is the company. There is no sign or seal on that to show, at least to prove that this was given.
Have you got a copy of the order?
Of the? No, I have not got the copy of the order.
No, he has produced it before the single bench.
We have produced that we have served upon them. The postal receipts and everything was produced before the honorable single judge to show and to satisfy the honorable single judge.
All right. Suppose we accept your case, and we say that in addition, you please serve one more copy. Based on that, let him file an appeal.
As your lordship will direct.
This intra-court appeal by the writ petitioner challenges an order dated 30/11/2023, by which the writ petition filed by the appellant challenging an adjudication order was dismissed. The ground canvassed in the writ petition was that the adjudication order was not served on the appellant. The learned advocate appearing for the department was able to produce documents before the learned single bench to establish that the adjudication order was served on the appellant. Therefore, we find that there is no error in the order passed by the learned single bench. However, we are of the view that the appellant should not be left remediless. Therefore, we direct the authority concerned to serve the one more copy of the order of adjudication on the appellant within in the address of the by speed post to the address of the SSC, and on receipt of the same, it is open to the SSC to work out his remedies in accordance with law.
Grateful to your lordship.
Next.
Serial number 19.
Yes, sir. 19.
My lords, I'm holding the brief on behalf of Mr. Rishi Raju. Due to some personal difficulty, has not been able to come today. Just praying, my lords, if the matter be
You
kept.
can't manage.
Lords, I've not read the brief and been never given.
Challenge the rectification, order of rectification by someone said. Though it is an appealable order before the tribunal. Where is Mr. Siddiqui?
My lords, I have been instructed also that if service is yet to be affected, I apologize. So kindly, sir.
They challenged an order of rectification by the WBGST authority. And the court said, because the tribunal is yet to be constituted, writ petition was entertained, affidavit in opposition to be filed within 4 weeks. And what do you want now? The interim order is required.
But as far as I can recall, my lord, in the rectification order, there is a review of the entire order of the appellate authority. The petitioner's contention is that in the garb of rectification, you cannot review the entire order.
Therefore, rightly the writ petition was entertained.
I'll come back to your lordship if
So both appellate power and rectification power both
are there in the act, my lord. It is a, my lord, in the provision. GST Act.
So what they say is, by virtue of rectification, you have virtually redecided the issue. Now, is there any demand which is probably
Lord,
because
that I do not know, because I will require a copy of the stay application and the memo of appeal.
August 2023.
Good. Pictures. 160, 161.
Already he says his senior is not there. You serve copies. There is no scope for passing any interim order here, because it is regarding cancellation of registration. When do you want it?
Anytime, my lords, next week.
Next week. At the request of some. Next.
Serial number 20.
I appear for the Lordship, this is that matter wherein your lordships had implemented the additional chief secretary PWD to ascertain whether why service tax was not paid to for the Singur work project. And from time to time, I was given stay from the service tax demand order, lordships. And now on 1st of 11, the PWD additional chief secretary has passed an order. But lordship, this order is also in gross violation, because your lordships in your last order has categorically stated to take into account the post facto approval. Lordships, may kindly take last order dated 16th of June.
Then you challenge this order.
This order has to be checked.
Lordship, it is after your lordship direction.
No, something has to be brought on record, no? You just hand over a piece
lordship,
of
I believe, lordship, this was supposed, they were supposed to give it before your lordships, but because
I also have the
you are more resourceful, you are able to get their records.
But I also have that.
Lordship, but not that fact. I can file an CAN application to
that we are not advising.
Lordship,
this has to be brought on record before this forum or before the single bench or sir.
No, lordship, before your court, I will then file a supplementary affidavit.
Obviously,
lordship,
otherwise we cannot test the.
Lordship, actually, it was listed today and this was received. It is dated 1st of November. It was received sometime in December. I will file a supplementary affidavit, lordships, keep on next Tuesday. Lordship, your Lordship's order dated second, the 16th of June, page number 2, para number 2, Lordships.
No, page number 3.
Lordship, just Lordship, page number 2, can I just read that? That is very important, Lordships. I read from the first line, Lordship, it is in the middle. Pursuant to the above direction, the Executive Engineer, Hooghly Highway Division, Public Works, Road Directorate, Government of West Bengal, passed an order dated this, rejecting the claim made by the appellant. On going through the order, we find that the authority has failed to appreciate the scope of the post facto approval granted by the PWD, Government of West Bengal, dated 6 June, in respect of a demolition work which was carried out by various contractors, and the works carried out by the appellant have also been mentioned in the annexure to the said order dated this. The expression post facto presupposes that it is after the decision has been taken. In the instant case, the post facto approval was granted much after the tender documents were put in place. Therefore, the authority ought to consider the effect of the post facto approval granted by the government. Since the executive engineer has not appreciated this expression in appropriate perspective, we are of the view that a higher official of PWD should consider the claim, for which purpose we so much to implement the additional chief secretary PWD. Now, Lordships, para number 3. In light of the above, the order dated 10/5 passed by the executive engineer set aside, and the entire matter is directed to be placed before the 6th respondent, who shall consider the representation by the appellant through his counsel dated 6/5 and 19/5/22 with specific reference to the post facto approval granted by the Government of West Bengal dated 6/6/17 and take a reasoned decision on merits and accordance. This was your Lordship's direction. Now, Lordship, I will bring a supplementary affidavit for this, Lordship. They have passed it.
This is 1st November order.
Lordship, after your Lordship's order, they called us for hearing. Kindly take, Lordships, page number 6. What they have written for that? Only last paragraph they have discussed. Page number 6, para number 13. Now, as per memo number this dated 6/6/17, there has been an incident of a post facto administrative approval for the project work demolition of this at an estimated cost of rupees this, including 3% and 15% service tax. First, an administrative approval is generally obtained in relation to contract for cost to be incurred. The contract, as we discussed earlier, was inclusive of taxes. Thus, when the administrative approval was sought for, tax was also stated. Further, it may be mentioned in this regard that the post facto administrative approval is meant for internal circulation, as it is evident from the fact that it is forwarded among the department only for information and necessary action and not to any contract. This is the only discussion. Lordship, the whole argument which was placed during the entire proceedings was, I was never registered with service tax because I was doing PWD road works, and it was specifically exempted under mega exemption notification 25/12. I was only registered with VAT. I was paying VAT because they're under works contract services for the works contract of VAT. Now, Lordships, after this work, this Singur demolition was done on a short approval notice. Whatever was signed, it was signed after the work was done, Lordship. Now, Lordship, 16/17 and 17/18 first 3 months, Service Tax Department comes to me in 2020. Basis my ITR, because my income tax return, I disclose every income. My road construction income was there, and this Singur project was there. They called me for the records. I produced all the records on the stating that I am unregistered because of these reasons. I was never registered with service tax. Now, Service Tax Department picks up this project, only this contract of demolition work of Singur, and says you have to pay service tax. Our claim was we are unregistered. We were never reimbursed. We are never given the service tax. And then we made representations to PWD. We came before your Lordships. Your Lordships directed PWD to be a party in the adjudication proceeding.
Yes.
Then, Lordships, in the adjudication order, PWD, in the adjudication proceedings, they were made a party. They came. And a demand order of service tax was passed, confirming our demand without considering the submissions. Then we again came before your Lordships. After the learned single judge denied our stay, then we came before your Lordships. Your Lordships took into account 2 factors. First factor was that this post facto approvals were never considered. How, when it is by a government order?
What is the effect of the post facto?
Lordship, post facto approval was 15% service tax that they are saying was a post facto approval. When the work was done, there was never service tax. Lordship, it's a government work. So if it is inclusive of service tax and say I am unregistered, then I will pocket that money. It can never happen in a government work, Lordship. When a government tender is issued, Lordship, I have to give the details of all my registrations. Then only the government will reimburse me service tax. I was unregistered. So the question of it being an inclusive service tax can never arise in this case. For VAT, I am not disputing. VAT I have always paid. And now, Lordship, and the second contention for the same amount. for the same amount which has been taken by the service tax department, the GST department came to me in 1819 and stated this amount because you have received after July 17. Though the work was done prior to July 17 when GST came, the entire amount you pay GST. And they have already recovered more than 80 lakh rupees in the disguise that this amount should suffer GST. Service tax department is telling this amount should suffer service tax. So considering both the aspects, your lordship, first on the ground that whether actually service tax is payable or not, therefore your lordships have taken this entire index. So lordship, and after this June order, we went before the PWD.
They don't deny the post facto approval.
They are not denying. And lordships, the first letter that they issued, they.
All right, you bring this on record. Pursuant to the orders, order dated 16th June 2023, the
Secretary PW.
The Technical Secretary, Public Works Department, has passed an order dated 1/11/2023.
It is passed by secretary. Technical secretary is only the last way, Lord. The
Passed by the Secretary of Public Works Department, dated 1/11/2023. The learned advocate for the appellant seeks time to file an application in this appeal to impugn the said order dated 1/11/2023. Let advance copy of such application be served on the learned advocates appearing for the respondents.
Lordship, supplementary affidavit or application? Affidavit, Lordship, will do because it is through the court order only. Therefore, a supplementary affidavit.
If you are challenging it, there has to be a prayer.
To quash that, why don't you file an application?
No, Lordship, I'm fine.
File an application.
I'll file an application.
The supplementary affidavit.
I'll file an application to bring this.
Yes, 2 weeks hence. Give a date after 2 weeks.
Serial number 21. Lordship, same position may be maintained because it is adjourned matter.
Yes, yes.
In serial number 21, I appear for Union of India.
Our affidavit also, he is coming with an application then. We need to file a application.
They are CGST department, service tax department, whose demand order has been stated.
All right, we'll give them some time also.
I'll file it.
Within 2 weeks. Sir, one more line you add. Reply by the respondents within a week thereafter.
Grateful.
So it will matter after 3 weeks.
Grateful.
Yes, sir. What is this?
Serial number 21.
My lord, I appear for Union of India. in 21.
Lordship, I pray for a short passover. My senior is before court 13, your lordship, on legs before court 13.
But the respondents say classification dispute will take time, my lord.
And ASG is also online.
Lordship.
I will say not today.
Or my lord, fix it next week, my lord. That will be better, I think, my lord.
So it can come before the other regular bench.
Yes, that will be better, my lord.
Then it has to be fixed after 11th. You say yes or no?
Okay, your lordship.
No, not okay.
You can say yes.
Yes, your lordship.
Say yes also, Mr. Sharaf will say, why you said it. If you say no, he will
Lordship,
come and say, why you
as
said
long as it's not on the 14th of January, your lordship.
14th, it won't be there.
No,
16th, we'll have it on 16th.
Yes.
No revenue matters are being going to be
Lordship
taken up
on Tuesdays.
Tuesdays.
Yes, your lordship.
Lordship's
So,
indication.
16th will be a Tuesday.
So 16 will be a Tuesday.
At the request of the learned advocate for the appeal. We'll fix it on 16th, ASG, sir.
Yes, my lord, yes.
Next.
Serial number 22.
May it please, Lordships. Lord, I am appearing for the appellant.
Who will appear for the respondent? Writings.
Lord, on the last day when the matter was taken up, on 6th of October 2023, your Lordship is pleased to grant us leave to file a supplementary affidavit. My Lord, we have served, but may we file the supplementary affidavit?
My lord, I want to file a opposition to the same and the main stay application also.
My Lord, may I only indicate, my Lord, here the point which
Give
was
them
taken.
10 days time.
My Lord, we'll come back. It's only a point, my Lord, where DRC 03, my Lord, payments was made in the course of the search and seizure proceeding, which is, my Lord, not voluntary. And I'm carrying judgments to that effect. It's only that point, my Lord, which I'll urge before your Lordships. But if they want to file an affidavit, we'll come back.
In terms of the liberty granted, in the order dated 6/10/2023, supplementary affidavit has been filed by the appellant raising certain additional grounds. The department is granted liberty to file their affidavit in opposition to the supplementary affidavit as well as to the stay petition within 2 weeks from date.
Well,
List the matter. Give a date after 3 weeks.
Deeply obliged, my lord. May we also file the affidavit of service, my lord?
Affidavit
Sir.
of service taken on record.
My lord,
Yes.
my lords, our reply, my lord, 1 week thereafter, my lord. They'll find
required.
it's not required, my lord.
Your affidavit and that
Very well,
make
my
your
lord.
submission.
We'll do so. Deeply obliged.
Serial number 23 to 25.
Let this matter will kindly take up. Give us some.
24, my lord, I'm appearing. Item number for the respondent.
My lord, there are a series of matters. My lord, 23, 24, 25.
Oh,
My lord,
there
that
is
would
an
be,
intermodal.
my lord, the jurisdictional issue, my lord, as to whether a 148(8)(d) and 148 notice has to be issued, my lord, in a faceless manner. My lord, there was one, my lord, division bench judgment, my lord, at the final stage, my lord, of the Telangana High Court, my lord, which we had relied on, which your lordships, my lord, on that basis had stayed, my lord, the proceedings. My lord, directions were also given for affidavits because, my lord, the revenue relied on, my lord, a notification. Your lordships wanted that to be put on affidavit. What's been put on affidavit now, which has been beyond time, is no notification. My lord, instructions given to counsel. Now, but my lord, we need to, my lord, file an affidavit in reply. My lord, the opposition was out of time by 2 months.
Lord, may I file my opposition? Item number 24, my lord. Item number 24.
All right. Leave granted to file affidavit in opposition to the affidavit, is it? Affidavit filed by the department in MAT 1838 of 2023.
My lord, that's item 24, my lord, before your lordship.
In FMA 873 of 2023. The affidavit in opposition filed on behalf of the second respondent in FMA this MAT 1690 corresponds to which FMA?
1690.
My lord, is FMA 873, my lord.
Affidavit in opposition on behalf of the respondent, number 2, in MAT 1690 of 2023 / FMA 873 of 2023 is taken on record. Give a date after 3 weeks.
And my lord, we'll file a rejoinder, my lord, in the meantime.
Liberty to file a rejoinder by the
only one thing, my lord, the matter is 3 matters are similar. My lord, now Mr. Duduri has filed an opposition, my lord. My lord, we see, my lord, that we will file or supplementary or not. My lord, if not that, this
you make legal submissions, no?
My lord,
multiply
Yes, my lord, because they wanted to rely on, my lord, a notification. Your lordships gave them that opportunity. And what has come is, my lord, instructions.
My lord, I would still like to rely on some notifications and not instructions.
The different courts view that, my lord, the assessment order that is, my lord, given to them, my lord, by the faceless officer or the, my lord, jurisdiction assessing officer, my lord, the no prejudice caused by the, my lord, assessee. This is very, very technical issue. And
see, that's a very vital issue. When Binami Transaction Act came into force, who was the proper officer? Very
that is not pan-India, that is pan-India effect. The Binami Transaction Act, the point is that the registered officer of the Binamdar, it is not that. It is not that. It is that the assessing officer, the jurisdictional assessing officer who is giving the by portal who is giving the assessee, or the faceless officer who is giving the assessment order to the assessee. Assessee will be not prejudiced.
Milord, I shall make this submission, Milord.
That is different. Binami Transaction Act, that is different, Milord. Section 24 of the Binami Transaction Act says different way.
Then the very chapter regarding faceless
I'm
assessment,
grateful.
it becomes otais.
No. Face,
I shall make my submission.
This scheme of the faceless is different. We will produce before you. Why the faceless come? That is totally different.
Oh, yeah, does it not substitute the earlier procedure?
No, we will be making the submissions supporting judgments of the Supreme Court also. And I'll make my submission.
My analyst senior appeal also will relying on instruction. We are also relying on instruction. That is all.
All right. Then give a date after 5 weeks.
Huh?
You rely on whatever you want after 5 weeks.
5 weeks for
5 weeks. In the meantime, we can file our reply.
Whatever you want, you file, sir.
I have done it.
Oh. Yes, next.
Serial number 26.
My lord, I am appearing on behalf of the petitioner.
I beg to appear on behalf of the state.
It is my application.
On behalf of the private respondent number 3, my lord.
Oh, we can't take up this matter. Review application.
Review application.
Yes, Hiranmay Bhattacharya was with me in that bench. So we will post it after 11th. He is in circuit.
After 11.
After 11. List the matter before the appropriate division bench on 16th January.
16th January, yes.
In the under the same heading, caption or heading, whatever.
Serial number 27.
This is also same order. Because
26.
16 January. Combination is different.
16 January, 16 January.
Serial number 28.
27.
No, 28, I appear for the High Court Administration.
Your Lordship, in item number 28, Mr. Partha Bhattacharya, learned senior advocate, is appearing. He is not present today in court. If that may be adjourned for a fortnight, Your Lordship, the matter.
Page 51 is the judgment under appeal.
হবে না বেঞ্চ দেখে দেখে দুটো
I think it's better I don't hear this matter. One file is being circulated.
Then, my lord, this has to be assigned.
We'll do the assignment. I'll do the assignment. Since one of us, within bracket, please put my name, is not inclined to take up this matter. Come on, let the matter be released from this bench and be assigned to be, and the papers be placed before the Chief Justice for assignment. Whatever usual order is making. Next.
Serial number 29.
Release for
Excuse me.
29, my lord, I am for the respondent number 2, my lord. This is a review. Order for recalling of an order passed by your lordship, sitting with the Honorable Justice Hiranmay Bhattacharya.
Oh, it has to come.
Yes, at 16th, your lordship has to be other. Not I appear for the state response.
Obliged, Lordship.
Release the issue.
Serial number 30.
Well, in this matter, I filed an application for modification of the order. By your lordship.
Lordship, I appear on behalf of the private petitioner.
Wait.
No service was made.
Wait, sir. Let him complete, sir.
I filed an application for modification of the order. By your lordship passed the order seeking justice, Honorable Justice Hiranmay Bhattacharya. Therefore, let this matter be adjourned to that day because it cannot be heard.
So it can't come on 16th. Already it's a lot of matter. 16. No. Please go. 30th January. Yes.
And 16th.
16th already lot of matters.
Lordship.
Next.
30 January. 30 January. Serial number 31.
My lord, it's also Justice Hiranmaya Bhattacharya.
Oh, recalling that on. All right.
But I'm for the respondent, my lord. I'm led by Mr. Gupta, this much for the High Court administration, my lord.
Next.
Serial number 32.
Date will be 16.
32, I am for the,
Pardon, sir?
they have filed an application for recalling of the order.
Recalling the order. All these are recalling application.
Yes, ma'am.
Up to which item? Up to 36, 35. So, item 30 to 35 are all application to recall the other. Okay. Then you give some date. 30 to 35, because it's other division bench composition, it will come before there.
That's the hearing. Your Lordship, item number 33, my review application.
This bench can't hear.
Well, it will appear on 16.
It will come. We will give the date.
January 3.
Justice Hiranmaya Bhattacharya is on circuit. You are aware of that?
Yes.
The combination is different.
Yes, Your
Though the name Bhattacharya is common.
Yes.
He is like Lordship Justice Supreme Bhattacharya. He is not Hiranmaya Bhattacharya.
Yes, sir.
So it will come before that bench. 5 matters. Next.
Your Lordship.
Item number 35, my lord. I am appearing for the petitioner, my lord.
First you call one by one.
Serial number 36.
Yes, sir.
Sir, I am petitioner in person.
What is the criminal contempt, sir?
Pardon, sir?
What is this application?
Sir, basically, there is a matter against me under the Protection of Women from Domestic Violence Act. And there was an ex-party order delivered within hours of filing of application. And I went to the district judge and the case was transferred to third additional district judge. After some 1000 days plus, there was a stay order from additional district judge, and there was a judgment, 18-page judgment, which is attached there along with the petition. Page number, I believe, 60 is the order, and prior to that, we have judgments. So there are 4 parts of this order which has not been obeyed by the subordinate court, where the matter is pending. First judicial magistrate at Barasat. The first part was I have outlined the 4 contention.
No, why can't you go before the additional session judge saying that your order has not been complied with? Where's the question of initiating criminal contempt?
Sir, because
you are appearing in person even in those proceedings, or you have got an advocate?
Sir, the additional district judge, he has set aside the ex-party order.
Very
of
good.
The,
and he has
matter.
directed them to appear. Parties are directed to appear before the learned trial court on 20th of May.
I appeared thereafter for some 6 or 7 dates, and till today, there has been absolutely no step taken up by the subordinate court.
So therefore, you say criminal contempt. What is the criminal contempt?
Because, sir, the contention is that, sir, the additional district judge, he has clearly said in his order that the first judicial magistrate will endeavor to dispose of the matter as per the spirit of.
Therefore, you go before. If you say criminal, you have to make out a case for criminal contempt. Where is the question of criminal contempt?
Sir, learned chair has not obeyed the order
you
of
go and
superior
complain.
authority.
We have heard that Mr. Mukund Mohan, petitioner appearing in person, on going through the averment set out in the petition And also, and after
Sir,
hearing.
I have one more point to make, sir.
Ah.
This is not the first contempt application. There was a contempt application last year, CRLCP number 08 of 2023. What happened was that learned additional district judge, he had given a stay order which was served to the first class judicial magistrate at Barasat, that there will be a temporary stay until the matter is pending before additional district judge. Still, a warrant was issued against me and I was harassed in that. And against that, I have also filed another contempt matter against the same learned chair of the subordinate court. So, sir, it is not the first contempt application I have against the same authority.
Yes. Petition, and after hearing the petitioner for a considerable length of time, we find this petition to be not maintainable. If, according to the petitioner, the trial judge has not obeyed the orders passed by the additional sessions judge, third court Barasat, there are other remedies open to the applicant to be exhausted, and this petition is dismissed as not maintained. Next, not maintained.
Serial number 37.
I appear on behalf of the petitioner, Lordship. Lordship, this emanates from a suit for partition of 1982. Lordship will see the first status quo order at page 49.
Why don't you move the concerned court? Why are you rushing to the High Court?
This was a status quo order firstly granted by the Honorable High Court.
All right.
Thereafter, at page 49, if your Lordship sees, thereafter the same order after 3 days had been adopted by the learned trial court.
So therefore, if that order is violated, why don't you approach the trial court? It has got enough and more powers. Why do you rush to the High Court for everything?
We have filed order 39 2A before the learned trial court.
Where is the application number? You please show the prayer. Yes, it is here.
Yes.
Page number 80, correct?
Yes. However, we only came to know regarding the contumacious
don't
act
do the
on
forum shopping, sir, please. This contempt of petition has been filed alleging willful disobedience of an order passed by the trial court. The appellant has filed a miscellaneous case number 10 of 2022 under order 39 rule 2 capital A of CPC with a prayer to.
If your Lordship kindly permits me to submit.
No. We try to hold the opposite parties as guilty of willful violation of the injunction order in the form of status quo, and to attach the personal properties of the opposite party and to send them to civil prison for willful violation of the interim order of injunction passed in this said suit. If such an application has already been filed, the present applicant should move the said application before the trial court. Instead of doing so, they have rushed to this court and filed this contempt petition. Hence, we are of the view that we are not inclined to entertain the contempt petition, and we give liberty to the petition applicant to seek for an early date for listing and disposal of miscellaneous case number 10 of 2022. And if such request is made, the learned first civil judge senior division at Chinchura, Hooghly shall assign an early date to the said petition and proceed in accordance.
But I was only taking refuge of some of the judgments, my lord, which says that despite
the court which passed the order will be more zealous in protecting the order.
Only thing is, because from an ad interim refusal, it was actually this honorable court's order.
Yes.
Actually, it was this honorable court's order which had, my lord, that was, my lord, the reason, my lord, why
go there and then come.
No, the remedy is not, my lord, equally efficacious. That is the whole reason, my lord, why we have come up in section 10, my lord. There are judgments, my lord, if your lordship kindly permits.
Not in some other case. Next.
Serial number 38.
What is 38, sir? IFB Industries. CPAN.
Again, my lord, a content, my lord, of my lord, order, my lord, passed by the
But why can't you move?
Powers are wider. Powers are wider, my lord, and my lord, and this person, my lord, particular person, my lord, repeated, my lord, their orders, repeated
I have
orders
been a
against him.
party to a division bench judgment in my parent high court, where we have said that merely because that's not an efficacious remedy, that doesn't mean that anybody can approach the high court.
No, that section, my lord, is there, my lord, so that would be, my lord, at some place, my lord, we have to exercise, my lord, that jurisdiction. Section 10, my lord, this is a case, my lord, where their orders, my lord, I'll tell, my lord, I'll take, my lord, just two sentences.
No. The reason why contempt petitions are to be listed before the very same bench or very same court which passed the order was to show that there is continuity. Second, the court knows under what circumstances is passed the interim or final order. And it will be more zealous in protecting such an order. So you don't even move. At least in the previous case, they have rightly moved the application.
If not, we have, my lord, an application. We have filed an application,
we'll ask
which is pending.
We'll ask them to advance it.
Lord, may I just make two submissions? Just two submissions. I'll not take, my lord, no. My lord, this particular, my lord, contemner, my lord, has not only violated the order of the law court, my lord, he claims to be, my lord, an investor forum. My lord, there's no such body. Now he goes on, my lord, writing letters, my lord, to everyone possible, and to, my lord, also, my lord, defame the company itself. My lord, we have orders, my lord, from our division bench also saying that you cannot represent, you cannot write. My lord, we also, my lord, approach, my lord, the Register of Farms to find out whether he exists. My lord, he doesn't exist. My lord, he also goes and files, my lord, as an advocate in record, my lord, he also files, my lord, matters. He's not an advocate. And now, my lord, there's an order of injunction which we served on him. My lord, he still, my lord, goes on, my lord, repeatedly, my lord, representing that forum.
Where is the application under 39(2)(a)? What is the miscellaneous?
My lord, page 64, my lord, will.
They can immediately order his arrest, civil arrest.
My lord, this is
65.
Page 60, yes, my lord. 64, my lord, 65, my lord, is right.
This contempt application has been filed alleging disobedience of an order passed by the so-and-so court, by the 5th Civil Judge Senior Division at Alipur. The applicant herein has filed a miscellaneous case under Order 39, Rule 2, capital A, read with Section 151 of the Code of Civil Procedure 1908, to punish the respondent for willful violation of the interim orders / directions issued by the learned trial judge. In the light of the pendency of the said application, we are not inclined to entertain this contempt application at this juncture, but would direct the learned 5th Civil Judge Senior Division at Alipur to give an early date for hearing of the said miscellaneous case filed under Order 39, Rule 2A, read with Section 151 CPC, and take a decision on merits in accordance with the law as expeditiously as possible.
Lord, I'm told, my lord, in fact, my lord, that learned judge, my lord, is there's the bench, my lord, they do vacancy, my lord, they do not even.
Discharge officer will be there.
Lord, then kindly, my lord,
we are informed that the said court is lying vacant.
Time, my lord, if
in such an event, the learned judge who is in charge of the said court shall give priority to the said application and fix an early date for hearing the application. Next, they will do it. This is sufficient.
My lord, if my lord, a particular, my lord, 1 month, my lord, either my lord, 1 month or my lord.
1 month, 1 week 1 week is sufficient.
Then my lord, kindly, my lord, provide for that, my lord. Kindly, my lord, provide for that.
Preferably within a period of 3 weeks from.
I'm so grateful.
3 weeks.
Grateful.
3 weeks. Yes, sir. We will do something.
Kindly, my lord, give me leave, my lord, to file the supplementary affidavit to show, my lord, aggravated, my lord, acts of contempt, my lord, still going on. My lord, we have given all, my lord, the documents. Let it be on record.
What is?
Well, just let it be on record, my lord. Let it be on record, my lord. At least, my lord, we can go back, my lord, and tell.
Because you have made photocopies of it. We don't have much space. Our building is sinking. They are saying that
is
all right. The supplementary affidavit is taken on record.
I'm grateful. I'm extremely grateful.
Serial number 39 to 45.
They are all. 39 to 45 will be listed on
41. 41.
You please tell them, no, inform me.
Sir, it hobe na karon eta
Combination is different. That's why the matter will be listed on next date. Serial number 46.
My lord, 41, I am appearing for the petition.
Different bench. You see who's beside.
Yes, my lord.
Serial number 46.
Our item number is 45, my lord. It's a contempt.
Next February, next.
It's a
Combination is
contempt.
One matter we have dismissed. Prithu Doria appeared.
Yes, my lord. Depository.
You file your.
Yes, my lord.
You raise your invoice.
Yes, my lord. Well, only thing item number 45, my lord, is my lord, contempt application.
It will come. It will come.
Yes.
46 is called.
Serial number 46.
This is order of. This is CPAN. No. All right. None appears for the applicant. Next week.
Serial number 47.
This is
My
my.
lord, we are opposing, my lord. We
this
think that means that this is not maintainable at all because, my lord, your lordship will kindly see only section 19(1) is the authority, means your lordship. And my lord, that it is not captioned in the section 19(1). And if the 9, my lord, containers are there, then only one container has come. But the section 12, clause 4 of the Contempt of Court Act specifically speaks that each and every individual who are responsible for it, who are the containers and who have been noticed.
We'll hear the senior advocate for the appellant.
And how? And my lord, another point, my lord, it is not maintainable in the sense that, my lord,
We will hear you on maintainable.
that how it is that only 136 is the.
My lord, this is an appeal, my lord, without finding the respondent, contemners, guilty of violating the order. The contempt court has no jurisdiction to pass an interim order. Unless when the court finds that there has been no violation of any order of court. The issue arises whether the contempt court, in a contempt petition, can pass an interim order.
But jurisdiction of a contempt court is also said to be curative, no?
That is only if there is some violation to cure. But when there is no violation to cure.
Right. What is the effect of the order of status quo?
Well, the order that was there, Lordship, previously, that is that Lordship kindly takes the earlier order that was subsisting.
No, the Board of Trustees are the appellants. And what will be the effect of the status quo order?
This effect of the status quo order, right of eviction. My right of eviction.
No, status quo as on September 25, 2023. What is the sanctity of that date?
That is the status quo without defining further can can lead to grave uncertainty. That is the whole. That's the whole point. This is the case of a license which has expired in December 2023, and eviction 10 years license. Eviction proceedings will have to be started. In the meantime, in September, there was an auction called for weighbridges installation by the Port Trust, in which the respondent, writ petitioner, did not participate. But they came before that in August, seeking for the 20 years renewal of their license. In the pending writ petition, they challenged the tender process. So when the matter is called writ petition, we submit that the tender does not concern your plots. Your plots are not affected. For your plots, I shall be taking eviction by due process of law. So we won't give the successful tenderer your plots by throwing out physically by force. That was recorded. Our assurance that we are not disturbing their possession so far as this tender is concerned, and we shall take due process. Tender is successful. Work order issued for allotting different plots for those 5 successful tenderers. Then a contempt is filed. Basis a resolution that was passed by the Board of Trustees 2 months before the order was passed, where it was contemplated that fresh tender will be given for those lands.
But in effect, these 5 people were never affected.
No, we are filing up. that tender, we have annexed the work order, is for different plots. The court finds this. Lordship kindly
therefore-
comes to the order.
No, the issue as to whether the court has got jurisdiction to pass such an order, interim order, we will examine.
Lordship will.
As of now, if those 5 sites have not been put up for fresh tender,
Yes, we have not.
and their status quo, they let it remain, you initiate eviction proceeding.
We have.
You
can-
proceed.
No, my lord, here, there is something. My lord, the area of operation, our interest will not be hampered, that is their undertaking.
How can that be?
But no,
We will evict them by
the
due process of
undertaking,
law.
my lord, that is the
That is
Supreme Court has
that's our
made.
fear. That is our,
Very
that
latest
is what the
judgment of the
status.
Supreme Court is.
That is what the
That means
status.
that it is their undertaking. Mr. Abrojit Mitra has given this undertaking before the Honorable Court, before Honorable Justice Vivek Chaudhary, at that point of time, that while that we will not disturb, we will not hamper the interest of the petitioner.
Yes, that is sufficient.
Then yes, if this is sufficient for contempt, but when
No,
you
no.
are, no,
What is the disturbance cost?
the,
Sir,
no, he is leading.
Ah.
My lord, the undertaking given was, my lord, that our interest won't be affected.
Very good.
They had, my lord, at that time, my lord, the tender was on. My lord, the learned judge on that basis did not pass any order. Now, my lord, in this order, it's been found that, my lord, by really circumventing that order, they're saying we are giving tender. But, my lord, the weighbridge, possibility of having a weighbridge is only in that area. So, my lord, in effect, they're affecting my interest. That is, my lord, the difficulty. If my lord looks at, my lord, the learned single judge's order, the learned single judge said you can't circumvent your undertaking in this manner.
Lordship kindly comes to the order impugned.
That is, my lord,
Order
the reason.
impugned, Lordship kindly.
Saying that you can't just circumvent when an order has been passed on your undertaking that you will not affect is two very important, my lord, things which were in the first order. My lord will find, my lord.
May I then just place this case, Lordship kindly takes the order impugned. Just the order impugned, page 3 of the order impugned. The page 3 in bold. What is recorded is the previous order. Since the learned advocates on behalf of the respondent, SPMP Kolkata undertakes, and the tender process does not involve the land sites and the 5 way bridges for which lease was granted to the petitioner. This court, relying on such undertaking, does not think it necessary to pass any interim order at this stage. This order also records, I will show, that we are taking steps by due process of law to evict them as and when the time expires.
That's a different matter.
That's it. Mr. Ratnanko Banerjee, learned senior counsel appealing for the petitioner, placed reliance heavily upon the undertaking given by the court authority quoted above and submit that even after giving such undertaking, the port authority was minded and decided to proceed with the tender process. But there's no bar with the tender process, which inter alia included the subject land and weighbridges being subject matter of the said tendering, said pending interlocutory application.
It is doing.
What are you doing? Please, you can't go on like this. This is
Either you appear or I
in this regard, he refers to documents of page 45 to so and so, which was already in existence when the said order of 20th September was passed. Now, Lordship kindly comes to page 5 of the order. Page 5 of the order. Second paragraph, Mr. So-and-so senior counsel appearing for the alleged contemners further submit on instruction that the port authority has not acted in any manner which amounts to violation of the undertaking recorded in the order, and the work order has already been issued under the tender process, is not in respect of the land sites or the 5 numbers of weighbridges which are the subject matter of the pending petition and the interlocutory application. This work order is at page 276. Doesn't relates to those. Matter is over. So, well, thereafter,
then how does the learned judge come to the?
That is the whole point.
How does
After
he come?
hearing the counsel for the parties and upon perusal of the materials on record, the courts of the firm view at the order of 20th September was passed inter alia clearly on the basis of the undertaking as recorded in the penultimate paragraph of 42. Exercising jurisdiction in contempt, this court shall only look into whether any contumacious act done in terms of 2B of the Contempt of Courts Act defining civil contempt. The definition of civil contempt inter alia includes violation of the undertaking given by the court. The law is also well settled. Not important. Next paragraph. This is on law. That the submissions made by Mr. So-and-so, by myself, learned senior counsel, appearing for the alleged contemners as recorded above would indicate that there was no violation of the undertaking given by the Port Authority before the coordinate bench.
Okay, now, the learned judge holds the documents in page 45 to 49,
Yes.
which was admittedly prior to the undertaking, was sort of giving a color as if you are trying to circumvent the order.
How can?
And where is the
I'll
context,
tell
sir?
my lord, I'll tell my lord.
My work order comes post.
No, no, we reiterate the undertaking.
I'm my lord the sole, my lord, I have my lord the sole payment bridge rights, my lord, in that area.
But that is not the case.
You can't.
Yes, page 111.
No, no, whose property is this? It's the property of the porter.
Lord, absolutely.
You are a squatter there.
No, no, I'm not a squatter.
If
My lord, my license, my lord.
If your license is over.
No, it
and
is not
you say
over.
10 years.
My lord, that's the subject matter. My lord, I'm also a government undertaking. My lord, I'm also a government undertaking.
Maybe you are a government undertaking.
Lord, may I just,
Sir, admit, sir, one thing.
It is not a tender.
So you see, the thing is, they have given an undertaking and the learned judge also comes to the conclusion there is no violation, but still says that some document which was created prior to the date on undertaking gives a color that they are trying to misinterpret. Where is the contempt here?
My lord, kindly see, my lord, last portion of the order. My lord, not to permit them to circumvent the order. And I'll show, my lord, how they're circumventing the order and the undertaking which was given. Because we made an application. My lord, I'm sorry, may I just complete, my lord, page 7.
Sir, this finding is damaging. The submissions of Mr. Mitrol and senior counsel appearing for alleged contempt
yes,
as recorded above would indicate that there was no violation of the undertaking given by the port authorities before the coordinate bench.
Yes.
He also reiterates on
same undertaking before this court as recorded above.
However,
they also.
The documents appearing in pages 45 to 49 of the contempt application, though is a document which came into existence before the previous order, September 25, was passed. But when undertaking was given, it is deemed that taking into consideration of that document, undertaking was given by the port.
Correct.
Keeping their eyes open.
Correct. The law of contempt demands that no party shall be allowed, very important, my lord, to circumvent or bypass any order or direction of the court.
Where is the bypassing? Where is
Well, that's what I'm showing. That's what I'm showing.
Please
Well, kindly come to, well, this one of the dispute is this. Well, we say it's a 30 years lease and they say, well, 10 years.
One public sector wants to kill the other public sector.
No,
Public sector wants to
There's no
no,
public
the
involved.
question is, well, which?
They have sublet to somebody
Which
else
public
who's
sector
running it
wants to
fully.
kill, well,
Fully
well,
says
page,
the
kindly,
private
well, come
sector.
to, well, page 110 at page 111. Well, indirectly, well, if you have, well, this, you are saying I'm not affecting your area. But, well, if you have women bridge in the next door, then quite naturally, well, my rights will get affected. And I'll show their undertaking how wide it was. Well, page 110 at page 111. Kindly, well, have a look.
Yes.
Kindly see, well, 1. Hindustan Steelworks Construction Limited will be the sole payment service provider within the port area as KDS and HDS. HCL will install and operate computerized 150 pit-ton road bridge at all operation roads, one motion bridge every such. Now, Malad, kindly see the undertaking, Malad. I want to show the order, which is the original order. 25th September 2023. That is, Malad, at page 317. Kindly, Malad, take 317.
Yes.
25th September. 317, Malad, will kindly take at three, two, one.
That's it.
I'm sorry, my lord. Since I'm troubling my lord, may I just trouble my lord from 319, my lord itself? I'm so sorry, my lord.
No, you please show the document which the learned judge has referred in his order, which were placed in the contempt.
I just show that
45 to 49.
My lord, but my lord, may I just before that just show the undertaking, my lord. So then, my lord, it is very clear, my lord.
327.
Yes, it is. 321, my lord. Kindly have a look, my lord.
And that too also, what was the resolution
No,
passed?
Mr. Mitra, you also. 321, kindly see, my lord.
Yes.
Mr. Sansal, learned senior, last portion, appearing on behalf of the Assembly, Kolkata, other hand submits, letter dated November 2013, cites in unqualified terms that the lease granted petition, sir. However, it is submitted by him that the tender in question does not involve the land sites and 5 number of way bridges for which lease was granted in favor of the petitioner. Well, next, by the impugned tender, the interest of the petitioner will not be hampered.
All right. Now, how is the interest being hampered?
Not if they have another way bridge next to mine.
Huh?
It is technical, quite naturally, unless they evict me, they can't get me off that land. But if they have it next door to mine, it is affecting my interest. And this is how, because we asked for injunction on the tender. That was CA1. We
all right, the injunction was not granted.
No,
You should
on his undertaking.
No,
I will show that. Can you just give me? I'm sorry, so sorry. Just 1 minute. Can you have a look? 322. By the impugned tender, this is undertaking. By the impugned representation, by the impugned tender, interest of the petitioner will not be hampered, and the SMP Kolkata shall take necessary action of removal of the petition due process of law. Also submitted by him that law on the subject is tried to the effects and such is that contract cannot be granted or party. Then kindly come to the last portion of the order. Submissions are made. And then at page 325. Last portion of 325.
Yes.
Since the learned advocate on behalf of the respondent undertakes that the tender process does not involve the land sites and 5 pavement bridge, lease was granted to petition. This court, relying on such, does not think it necessary to pass any interim order at this stage. And then I'll show those documents. Page 320. 7 can you see? This is the same tender they're pursuing. At 328 is the document. Pages 44, 45 the pages also appear in a meeting under the chairmanship. I'm so sorry.
328.
328. At the top, will find page 45 also written. That's from the original. In a meeting under chairmanship, Honorable Minister for Port Shipping, Such, Express, Innovation, all that goes on. Then let's see thereafter.
Yes.
Thereafter, I submit a design project wherein they recommend going for build, own, operate, maintain contract model to replace completely.
Sir, this was a decision taken on or in a meeting which was held on 28th of July 2022. It goes
to 3rd August 2023. At the top, will find item number Sansad dated 3rd August 2023.
3rd August is the item number. And the interim order or undertaking was recorded in order dated 25th of September 2023.
Yes.
So therefore, it goes without saying this 25th September order supersedes this decision as well.
That's right, and that's what the learned judge has protected. Because this is
where is the question of contempt?
This is the genesis of
No.
Genesis of the tender.
There cannot be a contempt on this.
Genesis of the tender.
If you have got a fresh cause of anger, in spite of that, if there is they are putting spokes or not allowing vehicles to travel inside.
I got an order on 25th September, or rather no interim order was passed on his undertaking, that it does not affect my interest. And there I had asked for stay of the same tender.
Now, indirectly, you are asking for a relief which was not granted to you. It is in effect, the contempt petition seeks review of the order passed by Justice Vivek Chaudhary.
The relief was not granted only on his undertaking. Otherwise, I would have got the relief.
No contempt at all, sir.
Otherwise, how do I enforce a undertaking?
You want to throttle them, that's all.
How do I enforce an undertaking? You give an undertaking on the basis of which
you have not demonstrated that post-undertaking, post-order dated 25th/9/2023, something has been done by the appellant, which...
Yes. They're proceeding on this basis.
No, the learned judge has recorded that this document is, see, you see that, let us go by what the learned judge has recorded, sir. He says, the submission of Mr. Mitro appearing for the alleged contempt as recorded above would indicate that there is no violation of the undertaking given by the port authorities before the coordinate bench. He also reiterates the same undertaking. However, the documents at pages 45 to 49, which you have showed now, though the same is a document which came into existence before the previous order was passed, but when the undertaking, it is deemed that it is in consideration. Where is the question of passing an order of status quo?
They proceed on the basis of that same tender which is going on. That is the decision.
What you should have done is you should have filed an intra-court appeal against this Vivek Chaudhary's order saying that this undertaking is not sufficient for me. Please protect me with a blanket order of injunction. Because without crossing my bridge, he cannot allow others to establish bridges. Second is, you want to be a monopoly, sir. Let this country get ruined. Everybody wants to monopolize. And under what circumstances Port Authority gave an undertaking to the court? Who gave the authorization? Was there anything in writing? Then
that we are not affecting their site. We will have it installed somewhere.
All right, sir. The council should have a written instruction from the concerned
On
chairman.
instructions, yes, on instruction.
This intra-court appeal.
My lord, one thing, my lord, one thing, your lordship. My
Yes, sit down. We have heard
no,
it.
no, my lord, that is one time be given, my lord, that at least we file written objection, my lord. At least, my lord, my lord, today is the first day. My lord, one thing, my lord.
All right.
My lord, what my submission
Senior
is.
counsel is not appearing for you.
No, yes, my lord, he is, but I am for one party also. My lord, there are two parties. My lord, one thing, my lord, what I am to submit, my lord.
No, you
my lord, kindly, my lord, it is the first day. My lord, that give us chance at least to have our written objection, my lord.
Yes, we are granting you.
My lord.
Don't raise your voice.
No, my lord.
Don't point a finger.
No,
No, I will deal with you differently.
But, my lord.
I will deal with you differently.
But, my lord, that it is the court of justice.
Yes.
My lord, if it is the court of justice, my lord, that in one shot, my lord, that your lordship will not say that it is.
No.
My lord, what I am saying.
Yes.
My lord.
All right. If you also point a finger, we'll also point
my lord,
finger.
with folded hand, I am saying, my lord,
We will
give justice, my lord.
we
What I
will
am
give
saying,
you
my lord,
opportunity.
with great respect to my learned seniors.
Sir,
My lord,
sir, you
and also with the
don't create ruckus in the
no, my lord, that I am not saying.
Hear us.
My lord, your lordship, my lord, kindly before passing order, my lord, your lordship, kindly see, my lord, heaven will fall, my lord, heaven will fall, my lord, if your lordship will pass some order, my lord, this order is a hasty decision your lordship is taking.
No.
My lord, your lordship
We will give you an opportunity.
No, my lord.
We are giving you an opportunity.
Yes, my lord.
You file your objection.
What, my lord? Because, my lord, yes, my lord. My lord, because, my lord, that the one thing I also, my lord, it is also clear. That means that even the hoodwinking the court, what I am saying.
No.
There will opportunity be given, my lord. Reason opportunity be given, my lord. It is not.
You are not hearing me. You are not hearing.
With folded hand.
Two weeks time you file your
I'm also
objection.
party, my lord. I'm also.
This intra-court appeal
Yes,
is directed against
opportunity be given at
order
least
dated
file our reason objection.
11/2023.
And my lord, till then, my lord. My lord, that is 2 days.
By the said order, the learned single bench has directed maintenance of order of status quo as on 25th September 2023 over and in respect of the said land sites and 5 numbers of way bridges to the extent of the issues and subject matter involved in interlocutory application being Can 1 of 2023 in so far as subject tender process is concerned, which is also subject matter of Can 1 of 2023. We have heard the learned senior advocate for the appellant as well as the learned senior advocate appearing for the respondent writ petitioners. As could be seen from the impugned order, the learned single bench, after recording the nature of undertaking given before the learned single bench, while passing the order dated 25/8/2023, has recorded as hereunder. Please, page 6 of Justice Roy's order, the paragraph starting the submissions. And to today also. From here. Page 6. After the above order was submissions were recorded, the learned single bench proceeded to observe that that certain documents which were relied on by the respondent writ petitioner proceeded to take note of certain documents referred to by the respondent writ petitioner. The learned single bench has also recorded that those documents are much prior to the interim order dated 25/9/2023, which is an admitted fact as they are dated 3/8/2023. In such circumstances, we find that we prima facie are of the view that the contempt application was not maintainable. Therefore, we entertain this appeal and there will be an order of stay passed by the learned single bench dated so and so impugned in this appeal. The respondents are directed to file their affidavits in opposition within 2 weeks from date, reply if any by the appellant within a week thereafter. Give a date after 3 weeks. Thank you.
My lord, one thing I am saying, my lord, should I say one thing? My lord, that hoodwinking the court is also on
Lordship's liberty to mention a matter, Lordship.